So laying out the elements in the order that I have proposed is my record. In other words, just so the record's clear, the defendant, Meggan Sundwall, too.
Hi, everybody. Hello, Sue. Welcome in. They are still arguing. Just some typo things that need to be straightened out on the jury instructions. There was a few other things argued that I'll talk about later. The jury was told to be there at 11-hour time. So the jury has probably just arrived and ready to hear closing statements. So I'm sure they're almost done with this.
Okay.
Next issue.
Again, I think the next one that's highlighted is obstructing justice, and I think the arguments have been made to Your Honor about whether multiple ways of doing that is going to be allowed. If not, I think that we keep it as is. If you're going to allow the argument of lying to the police to be part of it, I think we need to add in that as subsection B and C, as Ms. Haney instructed, and then I think that her additional language on unanimity would be appropriate. And then again, if the court does not allow another theory of obstructing justice, I think that we probably do need to have that unanimity instruction that says you may have heard that a crime happened more times than was charged. And that's in Muji. I don't have it in front of me, but I think that that would be appropriate to add.
Thank you. Mr. Williams, any thoughts? Other than what we've already discussed?
No, there'd be multiple. Okay. I mean, I guess it would be because there are multiple deletions. In other words, that could be the only argument, is there were multiple deletions of text, right? And so my record's made in terms of the different forms of obstruction.
Next issue.
Again, depending on what the court decides on count 2, if there's allowed a second theory, the unanimity on count 2 instruction that Ms. Haney has highlighted, we've added in, so in the paragraph, you may not find Ms. Sundwall guilty on this count unless you unanimously agree that the prosecution has proven. We added beyond a reasonable doubt there that Meggan Sundwall committed obstructing justice in at least one of the specific ways listed in the element 3 of instruction blank. And then at the very end, we added, if you find Ms. Sundwall guilty of obstructing justice, you must indicate your unanimous decision. We added in the language on the verdict form. And again, just trying to, for purposes of clarity.
And I made that change. Next issue.
Ms. Haney made a comment on the definition of intentionality. I can't speak for Mr. Williams. I do believe both counts are specific intent result crimes. So I think we agree with that. I think that instruction is fine. And then under the next instruction, definition of knowingly, we are taking out the lesser included offense of murder.
Your Honor, I don't think we have, for the record, a mens rea of knowingly here. Mens rea of aiding is intentionally acting. Then it says with knowledge that a person is. That is not, I submit, another mens rea in that statute. It's a question of fact. So I would object. Well, I guess that's not true. Murder has intentionally and knowingly as a mens rea. So that's just an awkward aspect as I started to speak through it. Murder does.
Thank you.
Never mind, sorry.
Agreed, aggravated murder does have intentionally or knowingly. Also, I would disagree with Mr. Williams, that aiding suicide does not include, it clearly says with knowledge that another individual intends to commit suicide. I think the legislature clearly could have used other verbiage. They used knowledge, which is a recognized mental state. So I think it's appropriate to instruct the jury on what knowledge means there as well.
Next issue.
Taking out recklessly definition entirely, the court's probably already done that.
Thank you.
And then I think the next issue is getting to the causation. I think that the state is largely okay with what the court has presented, but again, the state would request a definition of condition of peril. And then I also think that just for completeness sake, we would like intervening cause to be defined, because it's part of proximate cause, and then proximate cause, if condition of peril is included, it refers to proximate cause, which then in turn refers to intervening cause. So I think it would be potentially complicated on appeal if the jury doesn't have meanings for what those terms are.
Thank you, and I'll go back and make changes and come back with a ruling on those, so we're clear on the record.
And is it clear I object to that?
Yes. Any other issues with the instructions, or I guess we'll need to modify the verdict form?
We just had again, I don't know that it's terribly material, but the verdict form instruction toward the very end, the last sentence is, remember, any response you give on the verdict form must be unanimous. We changed it to, remember, all responses you give on the verdict form must be unanimous, just because obviously there's going to be multiple.
I'll think about that. Anything else from either party?
You know, I did come up with, I'm not sure if you decided, of course, yet, whether you might give it sort of duty to aid, but in my proposal, one other alternative, since it's language straight from the Good Samaritan Act, in other words, statutory language, is after in to aid another person who, we perhaps could say, may otherwise require emergency care. That's the language from the Good Samaritan. So it's just a proposal.
Thank you. Anything else before I go back and make changes and come back and make my ruling, and you'll get copies of everything?
This is, I can't point to any law. It's just not a way that I've seen it before, but on the verdict form, the list of the first thing listed is not guilty, and then followed by guilty of, obviously we'll take out reckless manslaughter and murder, but I've just never seen it. I can understand certainly why the defense would want it in that order. I'm sure that you can understand why the state wants it in a different order, but I think it makes more sense to descend in the order of guilty to not guilty, because that's kind of the path that they're, later instructed on to follow the different, inquiry A or whatever. We think it makes more logical sense to list the guilty offenses first and then not guilty. It just, I think, provides a clearer path for them to what they have to do, but I'll submit on that.
We don't have any precedent for that. It's just an argument. Is that correct?
Yes.
Yeah, we have some precedent. The starting point is not guilty in this country.
Thank you. All right. I'll go back and make my changes. I'll come out and rule on the two main instructions that we had detailed argument on. And the jury will
Excuse me.
be here in about 20 minutes. We'll get copies for them. You'll have copies. I'll give you a chance to review them. And then we'll get started.
Thank you, Your Honor.
Thank you all for your efforts. Be back in a moment.
All rise.
Hi, everybody. I got to get rid of that banner, don't I? Okay, let's hide the banner. Hello, Sue. Hello, Mickey. Posting today, so won't be watching chat closely. I'll check in every now and then. Hugs. Oh, yeah, Mickey, it is what it is. You don't want to watch. That's okay. I'll be here watching by myself, me and Sue. Welcome, everybody. So this morning, they started about, an hour ago, but the jury was told not to be there till 10 a.m., which is 11 Central Time. That's why I started at 11. But they were still arguing at 11, obviously, and now we got 20 minutes for the judge to consider what their arguments were. So what I gleaned from the arguments this morning is that the normal lesser included offenses of murder, which would be, negligence and reckless and things like that, those are not going to be part of the jury instructions. The lesser included offense here is, this was what the argument was. They wanted it to say, the state wants it to say that she created a condition of peril, and the defense wants to say murder. Because I don't know why. Anyway, that's the argument. But if you look at the statute, there's different ways to find murder on the lesser included offenses, which is reckless conduct, things like that. And then it'll go all the way down to this little bitty one on the bottom that says created a condition of peril. Now, the defense argued, I don't know. I know. Thank you, Sue. I don't know if she really created a condition of peril. And then the state came up with this wild theory. Well, we think that Casey drew up saline into the syringes and injected herself with the saline, and that Meggan got wise to it and she actually injected it. So what? There's no evidence of any of that, except maybe in a text message, but that really happened. I don't know. Anyway, although, there was no insulin found in the syringes. So, I mean, we don't know how she got the insulin. Did she give it to herself? Did Meggan? We don't know. So what condition of peril did Meggan create? This woman created her own peril, if you ask me. But anyway, they want that as part of the jury, the lesser included offense jury instruction. So if they find her not guilty of murder, they can go down and argue, did Meggan create a condition of peril? Okay. And then we're talking about obstruction of justice. The state wanted the instructions to say that there were two ways that they could find it. One, that she deleted these text messages, and two, that she lied to the police when she said, I don't know what happened. So who knows? Even if he'll probably just leave it at the one that she deleted the text message, because they're allowed to argue that, there could be other ways that she obstructed, but they don't have to charge every single obstruction of justice. In other words, she deleted 263 text messages. They don't have to charge her 263 times or 264 times for, the lying to the police. It's all kind of one thing. She was obstructing justice. So, and this is just all has to do with in jury instructions. So on the lesser, I'm sorry, I said murder. So I didn't mean murder, manslaughter. Different ways to find manslaughter. So if they find her not guilty of murder, they go to manslaughter, and under manslaughter, the state is going to argue that she created a condition of peril. That makes way more sense, right? I need more coffee, except I've already had enough coffee and I'm on to Sonic lemonade. So we're waiting for the judge, he's going to go back, rule on all the stuff that they argued this morning, change the jury instructions accordingly, make the copies, blah, blah, blah. Says he'll come back in 20 minutes, and then we'll get into the closing arguments. So how are you, Sue? I'm great. Just great. Yeah. So I'm going to put the court feedback on, and I'll be back when the evidence starts.
Thank you for your patience, everybody. We're going to go back on the record on case 251-401-132, State of Utah versus Meggan Sundwall. We have had discussions this morning with counsel as it relates to proposed jury instructions, requested changes, and additions. I'm going to make a ruling on a couple of those and explain what we've done. You've got your final proposed instructions that I intend on using. After I've made those rulings, we're going to take a 15 to 20 minute break so we can make copies of the instructions to give them to the jury. Then we're going to come out and get started. Does that work for everybody?
Yes, sir, Your Honor.
All right, as it relates to the causation issue and my ruling on that. The state, relying on State v. Hallett and State v. Boss, requests an instruction on a defendant creating a condition of peril as part of the causation instruction. The condition of peril language comes from 2 negligent homicide cases where the defendants in those cases created a circumstance or condition where there was a risk of death. Importantly, in those cases, the appellate courts connected the condition of peril to the defendant's knowledge that the condition created a risk of death. A risk of death is a criminal negligence standard. In our case, no party has asked for a negligent homicide instruction. Instead, Ms. Sundwall is charged with aggravated murder, which requires the state to prove that she acted intentionally or knowingly in causing the death of another. When a person acts knowingly, they create more than a risk of death. Instead, they create a condition where death is reasonably certain to occur. It requires more than a condition of peril. It requires creating a condition where death is reasonably certain to occur. If the court instructs on a condition of peril, the court may, in a sense, relieve the state of a burden to show an intentional or knowing homicide. In the same vein, manslaughter in our context requires an intentional and knowing mental state. Accordingly, the state's request for a condition of peril instruction is respectfully denied. The state also asked for an instruction on intervening cause. Halfway through oral argument this morning, the state conceded that the court's proposed instruction on causation was sufficient to explain this principle to the jury. Then at the end of oral argument, the state raised its request for an intervening cause instruction again. The court has considered the state's request. The state has not provided a sufficient basis either in the evidence or in case law for the court to introduce a new principle to the jury on causation. The court will instruct on causation as it has already drafted. The state's request is respectfully denied. As to the defendant's request for an instruction on no duty to aid, defendant requests an instruction on no duty to aid another. Neither party has provided case law that requires the court to instruct on this principle, which seems to come from civil common law context. The court is already instructing on causation, which requires the state to prove beyond a reasonable doubt that the defendant's conduct was a substantial factor in bringing about Miss Terry's death, and that without Miss Sundwall's conduct, Miss Terry would not have died. The state also has to prove that Miss Sundwall either desired Miss Terry's death or that her conduct was reasonably certain to cause Miss Terry's death. This is the correct statement of law in criminal cases, and this is the standard that the parties may argue in closing. Defendant's request for a no duty to aid instruction is respectfully denied. However, the court does intend to instruct the jury with the following, and has added this in the final instructions in instruction number 40, which is included. This will be read to the jury. You have heard evidence that Miss Sundwall is a registered nurse. You may consider this evidence, if at all, to determine her mental state at the time of the alleged offense. However, you must not consider Miss Sundwall's background as a nurse as requiring a special duty to provide medical care beyond that of an ordinary person. Counsel, you will also note that the court has found good cause to modify instruction number 34 regarding obstruction of justice based upon the evidence as outlined in trial and at the state's request. I'm going to give you 15 to 20 minutes to review those, to finalize your closing statements. We're going to get the binders ready for the jury. We'll come back in, read instructions together, And then you'll start with your closings.
With no lunch break, Your Honor.
With what?
No lunch break.
Nope. They're gonna have lunch waiting for them when they come back in, so they will be ready to get to work. Again, I appreciate everybody's patience. We'll be back in a moment to get going. Thank you.
All right.
So once again, we have another break. But that was huge. That was really, really huge. Where's my notebook? Hold on. So the state lost on their argument for the condition of peril, which I'm kind of glad about, because I didn't agree that she created a condition of peril. And clearly the judge did not either. So putting in there that she created a condition of peril, that's not happening. So all the jury would have to find is that she intended to cause the death. And I don't think they're going to find that she intended to cause the death here. In any case, the defense did not win either. They wanted duty to aid to be part of the instruction, that she had no duty to aid here, which what he explained was it's basically a common law thing. And it really has more to do with the Good Samaritan law. So like if you come upon someone in an accident, you have no duty to aid. That's kind of where that renders. And even if you do aid, because you didn't have a duty to begin with, the Good Samaritan law kind of protects you with the aid that you do happen to render. But if you decide you don't want to render any aid, you don't have a duty to. So that's not in the jury instructions. But what he did add was the fact that the jury is not allowed to consider the fact that she was a registered nurse. She wasn't there as part of a hospice team. She was there as Casey's friend and close pseudo family member to basically watch her die. I mean, I can see maybe a manslaughter verdict here, but I don't see a murder verdict coming down today if they ever get to it. So he did say no lunch break. He has ordered the jury some lunch. I have not heard anything about limiting the arguments of counsel, so I don't know how long these things are going to go. The openings weren't terribly long, and please do not put that woman up there that has that soft voice. Please don't do that to us, because she just drives me nuts with her soft voice. The defense attorney, he's good. I can't wait to see what he does with this, but I think, my guess is that we're looking at a not guilty or a hung jury here. That's my guess, because I agree. She didn't have a duty to do anything. She showed up based on all of this nonsense her friend was telling her. She showed up to someone who she thought had cancer, a broken leg. She was terminal. She was on hospice. This was the end. She had to do not resuscitate. This is what she thought coming into the scene. She certainly didn't create a condition of peril. At least not. That's my opinion. Anyway, so we're on another break, folks. So I will see you in a little while. Go get some lunch real quick. And he said, 15 minutes? That means an hour. All right, we'll see you soon.
Not that I'm asking for it.
Thank you for your patience. Oh, yes. Come out for just a second.
Back this way, really.
Sorry about that. Please be seated. That'll just give more time to get some more caffeine.
Could you maybe let the jury know that the reason he has to do that is his son wants to use the bathroom?
I'm happy to do so.
Judge,
Yeah, I think they did.
Judge, can I come and turn the lectern before making a
Of
big
course.
scene in
Yep.
front of the?
Thanks, Mr. Williams. That was just a dress rehearsal.
There we go. Now we're on practice. All right.
Please be seated. Court will go on the record on case number 251-401-132, State of Utah versus Meggan Sundwall. Ladies and gentlemen of the jury, thank you for your patience. Sorry about that initial dress rehearsal. Sundwall was in the bathroom, so we're all ready to go. Hope you all had a good weekend. We're going to go through closing instructions right now. You've each got your binders. We're going to read through every instruction together, after which we're going to hear closing arguments, and then you will be excused to deliberate. Once again, we all thank you for your attention and efforts in this matter. If you could please turn to instruction number 13. Everybody there? Closing roadmap. All right, let's get started. Instruction number 13, closing roadmap. Members of the jury, you now have all the evidence. 3 things remain to be done. First, I will give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. The prosecutor will go first, then the defense. Because the prosecution has the burden of proof, the prosecutor may give a rebuttal. Third, you will go to the jury room to discuss and decide the case. Instruction number 14, juror duties. As jurors, you have two main duties. The first duty is to decide from the evidence what the facts are. Deciding what the facts are is your job, not mine. You are the exclusive judges of all questions of fact. The second duty is to take the law I give you in the instructions, apply it to the facts, and decide if the prosecution has proved the defendant guilty beyond a reasonable doubt. You are bound by your oath to follow the instructions that I give you, even if you personally disagree with them. This includes the instructions I gave you before trial, any instructions I may have given you during the trial, and these instructions. All the instructions are important, and you should consider them as a whole. The order in which the instructions are given does not mean that some instructions are more important than others. Whether any particular instruction applies may depend on what you decide are the true facts of the case. If an instruction applies only to facts, circumstances that you find do not exist, you may disregard that instruction. Perform your duties fairly. Do not let any bias, sympathy, or prejudice that you may feel toward one side or the other influence your decision in any way. Instruction 15, legal rulings. During the trial, I have made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustain an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. Instruction number 16, judicial neutrality. As the judge, I am neutral. If I have said or done anything that makes you think I favor one side or the other, that was not my intention. Do not interpret anything I have done as indicating that I have any particular view of the evidence or the decision you should reach. Instruction 17, evidence. You must base your decision only on the evidence that you saw and heard here in court. Evidence includes what the witnesses said while they were testifying under oath, any exhibits admitted into evidence, and any facts to which the parties have stipulated. That is to say, any fact to which they have agreed. Nothing else is evidence. The lawyer's statements and arguments are not evidence. Their objections are not evidence. My legal rulings and comments, if any, are not evidence. In reaching a verdict, consider all the evidence as I have defined it here and nothing else. You may draw all reasonable inferences from that evidence. Instruction number 18, items not admitted into evidence. Transcripts, police reports, or other written audio or visual materials may have been referenced during the trial, but not admitted as exhibits. It is common during deliberations for jurors to ask to review these materials or to have transcripts of what witnesses said during trial. These materials, other than what may have been admitted as exhibits, may not be requested as part of your deliberations. Instruction number 19, witness credibility. In deciding this case, you will need to decide how believable each witness was. Use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you are convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one or one witness against many. In deciding whether a witness testified truthfully, remember, no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same thing, same event differently. Instruction number 20, fact and expert witnesses. There are two types of witnesses, fact witnesses and expert witnesses. Usually a fact witness can testify only about the facts that he or she can see, hear, touch, taste, or smell. An expert witness has scientific, technical, or other special knowledge that allows the witness to give an opinion. An expert's knowledge can come from training, education, experience, or skill. Experts can testify about facts and they can give their opinion in their area of expertise. You may have to weigh one expert's opinion against another's. In weighing the opinions of the experts, you may look at their qualifications, the reasoning processes the experts used, and the overall credibility of their testimony. You may also look at things like bias, consistency, and reputation. Use your common sense in evaluating all witnesses, including expert witnesses. You do not have to accept an expert's opinion. You may accept it all, reject it all, or accept part of it and reject part. Give it whatever weight you think it deserves. Instruction number 21, testimony of a law enforcement officer. You have heard the testimony of one or more law enforcement officers. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is up to you to give any witness's testimony whatever weight you think it deserves. Instruction number 22, direct and circumstantial evidence. Facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified that he looked outside and saw it was raining, that would be direct evidence that it had rained. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone can conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. It is up to you to decide. Instruction number 23, presumption of innocence. Remember, the fact that Meggan Sundwall is charged with a crime is not evidence of guilt. In addition, the defendant does not have to prove anything. The defendant does not have to testify, call witnesses, or present evidence. Indeed, the law presumes that the defendant is not guilty of the crime charged. The presumption of innocence persists in favor of the defendant unless the prosecution's evidence convinces you beyond a reasonable doubt that the defendant is guilty. The prosecution carries the burden of proof at all times, and the prosecution must prove each and every element of a crime beyond a reasonable doubt. Until the prosecution has satisfied that burden, you must presume the defendant is not guilty. Instruction number 24, beyond a reasonable doubt. The prosecution has the burden of proving the defendant guilty beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with an absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there is a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty. Instruction number 25. Defendant chose not to testify. A person accused of a crime may choose whether or not to testify. In this case, the defendant chose not to testify. Do not hold that choice against the defendant. Do not try to guess why the defendant chose not to testify. Do not consider it in your deliberations. Decide the case only on the basis of the evidence. The defendant does not have to prove that he is not guilty. That she is not guilty. The prosecution must prove the defendant's guilt beyond a reasonable doubt. Instruction number 26. An offense requires both conduct and mental state. A person cannot be found guilty of a criminal offense unless the prosecutor proves that the person's conduct is prohibited by law and at the time the conduct occurred, the person demonstrated a particular mental state specified by law. Conduct can mean both an act or the failure to act when the law requires a person to act. An act is a voluntary movement of the body and can include speech. As to the mental state requirement, the prosecution must prove that at the time the person acted or failed to act, he or she did so with a particular mental state. For a criminal offense, the law defines what kind of mental state the person had to have, if any. For some crimes, the defendant must have acted intentionally or knowingly. For other crimes, it is enough that the defendant acted recklessly, with criminal negligence, or with some other specified mental state. Shortly, I will instruct you on the specific conduct and the mental state that the prosecution must prove beyond a reasonable doubt before the defendant can be found guilty of a crime. Instruction number 27, inferring the mental state. The law requires that the prosecutor prove beyond a reasonable doubt that the defendant acted with a particular mental state. Ordinarily, there is no way that a person's mental state can be proved directly because no one can tell what another person is thinking. A person's mental state can be proved indirectly from the surrounding facts and circumstances. This includes things like what the person said, what the person did, and any other evidence that shows what was in the person's mind. Instruction number 28, consideration of multiple offenses. Meggan Sundwall has been charged with more than one crime. It is your duty to consider each charge separately. You do not need to consider the charges in any particular order. For each crime charge, consider all of the evidence related to that charge. Decide whether the prosecution has presented proof beyond a reasonable doubt that the defendant is guilty of that particular crime. Your verdict on one charge does not determine your verdict on any other charge. Instruction number 29, do not consider punishment. In making your decision, do not consider what punishment could result from a verdict of guilty. Your duty is to decide if the defendant is guilty or not guilty. Punishment is not relevant to that decision. Instruction number 30, defendant's charges. Meggan Sundwall is charged with the following crimes. Count 1, aggravated murder. Count 2, obstruction of justice. To these charges, the defendant has entered pleas of not guilty. These pleas cast upon the state the burden of proving beyond a reasonable doubt all of the elements of the crimes charged. These elements are set forth in the following instructions. Instruction number 31, count 1, lesser included offense. Count 1 charges the defendant with aggravated murder. Manslaughter is a lesser included offense of that charge. As you deliberate, you must determine whether the defendant is guilty of aggravated murder, guilty of manslaughter, or not guilty of either offense. The law does not require you to make these determinations in any particular order. However, you cannot find the defendant guilty of more than one offense. In other words, you can only return one verdict on count 1. Guilty of aggravated murder, guilty of manslaughter, or not guilty. The elements for aggravated murder are set forth in instruction 32. The elements for manslaughter are set forth in instruction 33. Instruction 32, elements of count 1. Aggravated murder. Meggan Sundwall is charged in count 1 with committing aggravated murder on or about August 12, 2024. You cannot convict her of this offense unless, based on the evidence, you find beyond a reasonable doubt that each of the following elements. 1, the defendant Meggan Sundwall. 2, intentionally or knowingly. 3, cause the death of Casey Terry. 4, under one or more of the following aggravating circumstances. A, the homicide was committed for pecuniary gain. Or B, the homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proved beyond a reasonable doubt, then you must find the defendant guilty of aggravated murder. On the other hand, if you are not convinced that each and every element has been proved beyond a reasonable doubt, then you must find the defendant not guilty of aggravated murder. To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one aggravating circumstance listed in element 4 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the state's proven. Instruction number 33, elements to the lesser included offense of manslaughter. You have been instructed that manslaughter is a lesser included offense of aggravated murder. You cannot convict Meggan Sundwall of manslaughter unless, based on the evidence, you find beyond a reasonable doubt each of the following elements. 1, the defendant Meggan Sundwall. 2, with knowledge that another individual intended to commit suicide or attempt to commit suicide. 3, intentionally aided the individual to commit suicide. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proved beyond a reasonable doubt, then you must find the defendant guilty of manslaughter. On the other hand, if you are not convinced that each and every element has been proved beyond a reasonable doubt, then you must find the defendant not guilty of manslaughter. Instruction number 34, elements of count 2, obstruction of justice. Meggan Sundwall is charged in count 2 with committing obstruction of justice on or between August 12, 2024 and August 19, 2024. You cannot convict her of this offense unless, based on the evidence, you find beyond a reasonable doubt each of the following elements. 1, the defendant Meggan Sundwall. 2, with the intent to hinder, delay, or prevent the investigation, apprehension, prosecution, conviction, or punishment of any person regarding conduct that constitutes a criminal offense. 3, did one or more of the following: A, altered, destroyed, concealed, removed any item or other thing, namely deleted text messages between the defendant and Casey Terry, or B, provided false information regarding the conduct constituting an offense or any other material aspect of the investigation, namely lied to law enforcement. After you carefully considered all the evidence in this case, if you are convinced that each and every element has been proved beyond a reasonable doubt, then you must find Meggan Sundwall guilty of obstruction of justice. On the other hand, if you are not convinced that each and every element has been proved beyond a reasonable doubt, then you must find her not guilty of obstruction of justice. To find the defendant guilty of obstruction of justice, you must unanimously agree the prosecution has proven at least one act listed in element 3 beyond a reasonable doubt. You must also unanimously agree which acts the state has proven. You must also unanimously agree which criminal offense investigation she obstructed. You will reflect your decisions on the verdict form. Instruction number 35, definition of intentionally. You are instructed that a person acts intentionally or with intent when her conscious objective is to cause a certain result. Instruction number 36, definition of knowingly. For purposes of count 1, aggravated murder, a person acts knowingly or with knowledge when the person is aware that her conduct is reasonably certain to cause a particular result. For the lesser included offense of manslaughter, a person acts with knowledge when the person is aware of the nature of her conduct or is aware of the particular circumstances surrounding her conduct. Instruction number 37, usual and ordinary meanings. Unless these instructions give a definition, you should give all words their usual and ordinary meanings. Instruction number 38, other definitions of terms. For pecuniary gain means the acquisition of money or something of monetary value. Aid means the act of providing the physical means and does not include the withholding or withdrawal of life-sustaining treatment procedures. Providing means to administer, prescribe, distribute, or dispense. Cause the death means that the defendant's conduct was a substantial factor in bringing about the death of another, even if it can be shown that some other factor also contributed in a substantial degree to the death, as long as the other factor was foreseeable. The death would not have occurred but for the defendant's conduct, and a reasonable person would have foreseen that the defendant's conduct would have resulted in death. Instruction number 39, evidence of other acts by the decedent. You have heard evidence that the decedent, Casey Terry, may have unlawfully used her grandparents' funds before the incident charged in this case. This evidence was not admitted to prove a character trait of Casey Terry or to show that she acted in a manner consistent with that trait. You may consider this evidence, if at all, for a limited purpose of determining whether Casey Terry had a motive to die by suicide. Keep in mind that Casey Terry is not on trial in this case. Instruction number 40, evidence of defendant's background. You have heard evidence that Ms. Sundwall is a registered nurse. You may consider this evidence, if at all, to determine her mental state at the time of the alleged offense. However, you must not consider Ms. Sundwall's background as a nurse and as requiring a special duty to provide medical care beyond that of an ordinary person. Instruction number 41, closing arguments. When the lawyers give their closing arguments, keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Instruction number 42, jury deliberations. After the attorneys have completed their closing arguments, the bailiff will escort you to the jury room, and you may commence your deliberations. When you have agreed and the verdict form has been signed, please notify the bailiff. Do not reveal your decisions to the bailiff. The foreperson must keep the form in his or her possession until I instruct you otherwise. Instruction number 43, jury deliberations, unanimous agreement. Because this is a criminal case, every single juror must agree with the verdict before the defendant can be found guilty or not guilty. That is, you must be unanimous in your verdict for each count charged. To help you in reaching unanimous agreement, I recommend that you not commit yourselves to a particular verdict before discussing all the evidence. In addition, you may not use methods of chance, such as drawing straws or flipping a coin. Rather, in the jury room, consider the evidence and speak your minds with each other. Listen carefully and respectfully to each other's views and keep an open mind about what others have to say. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. A unanimous verdict must reflect the individual, careful, and conscientious judgment of each juror as to whether the defendant is guilty or not guilty. Instruction number 44, foreperson duties. Among the first things you should do when you go to the jury room is to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinion should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. Instruction number 45, verdict form. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into two sections, one section for each count charged. Each count has separate instructions. When rendering your verdicts, you need to make sure only one verdict for each count is marked. You may be asked additional questions about the basis of your verdicts. Remember, all responses you give on the verdict form must be unanimous. Instruction number 26, questions during deliberations. These instructions should contain all the information you need to decide this case based on the evidence. However, if you have a question or need clarifications during deliberations, write a note and give it to the bailiff. I will review it with the lawyers. We will answer your question as appropriate. We'll now read the verdict form that you will consider. Read the instructions carefully. Be sure to mark only one verdict for each count. Count 1, aggravated murder. We, the jury, unanimously find the defendant, Meggan Sundwall, is not guilty. Guilty of manslaughter, guilty of aggravated murder. If you mark guilty of aggravated murder, you must answer inquiry A. Inquiry A. You must only answer this inquiry if you marked guilty of aggravated murder. We, the jury, unanimously agree the prosecution has proved the following aggravating circumstances beyond a reasonable doubt. Check all that apply. Your decision to mark any aggravating circumstance must be unanimous. This homicide was committed for pecuniary gain. The homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity. Count 2, obstruction of justice. We, the jury, unanimously find the defendant, Meggan Sundwall, is not guilty of obstruction of justice. If you mark guilty, you must answer inquiry B and inquiry C on the next page. Inquiry B. We, the jury, unanimously agree the prosecution has proved the following acts beyond a reasonable doubt. Check all that apply. Your decision to mark any act must be unanimous. Defendant altered, destroyed, concealed, or removed any item or anything, namely deleted text messages between defendant Casey Terry. Defendant provided false information regarding the conduct constituting an offense or any material aspect of the investigation, namely lied to law enforcement. Inquiry C. We, the jurors impaneled in the above case, have found that Meggan Sundwall, guilty beyond a reasonable doubt of obstruction of justice as to count 2 of the information, unanimously find beyond a reasonable doubt the defendant obstructed the investigation of the following criminal offense. Choose one. Your decision must be unanimous. Aggravated murder, manslaughter. Those are your instructions. You can refer to them as needed. Is the state ready to proceed?
We are, thank you, Your Honor. This case boils down to one question: who was in control? In this case, when you step back and look at all of the evidence that you've heard over the last few weeks, you get clarity. What happened in the years, months, weeks, and ultimately what happened down in that basement on August 12th, 2024 was not chaos. It was not confusion. It was not a tragic misunderstanding. It was not a best friend merely helping out her other best friend in the whole world. This was control. And the person who was in control during that entire time frame sits at that table: Meggan Sundwall. The judge instructed you on credibility, and that's in instruction 19. I won't read over it entirely again. You just heard it from the judge. But when you evaluate the evidence, use your common sense. Look at all these factors in instruction 19 and your human experience to determine credibility. You look at whether things make sense in real life. You ask, does the story match the evidence? Do behaviors and patterns match human experience? Do certain patterns match what we've heard or learned about during testimony? When you apply those rules here, the evidence does answer one central question: who was actually directing, controlling, and causing what happened to Casey? The answer is Meggan Sundwall. Let's talk about Casey. What do we know about her? First, let's be clear about something the state is absolutely not running from. Casey lied. She exaggerated illness. She misused medication. She made some poor decisions. Both sides, I think, can agree about that. She was a flawed person. She was a hurting person. The evidence shows, though, that she had real medical issues from early in life. She was only born with one kidney. She had surgery. I believe we heard it at like 3 weeks old from that. She was exposed to long, early medical treatment. She lost her mother as a small child and her father as a teenager. Over time, she learned that medical crises brought attention, care, and connection. Much of her dishonesty centered around health. That context matters not to excuse her behavior, but to understand her vulnerability. Even with the cancer lie, let's look at that, because she certainly did lie to many people about that. She lied to her family. But with her family, they were actually seeing objective factors, objective things that made parts of her story seem believable. Medical supplies were being delivered to the home. She had a port. She had real infections associated with that port. She had legitimate knee surgery and physical therapy. She went to appointments and emergency rooms and other doctors. Now, the family are not medical professionals. They were trying to make sense of what they were seeing and what Casey had told them. And she had not told them the level of dramatic lies that she told to Meggan Sundwall, who was a nurse. The defense has suggested throughout this trial that Casey's life was collapsing, that she had built this house of cards and it was falling, that she was part of a drug network, stealing money and facing exposure that gave her a real motive to end her life. But the actual evidence does not support a sudden house of cards falling. Her prescription records show in the early, what you'll see, you can review it. In the early years, yeah, she may have been doctor shopping a little bit. She was going around getting opioids from different sources. We heard from Dr. Masteller that it was harder for doctors to check the Doppel records at that point to see if that was happening. But after that, what we see is what Dr. Masteller testified to. Pretty routine opioid prescription. I think you'll see in that exhibit, it's monthly. Dr. Masteller talked about that, and he talked about that they even had a plan to wean her off of that. And then at the end, when the defense asserted that it really ramped up at the end, she had a knee surgery. And Dr. Masteller testified that that's consistent with extra pain management that would have been needed for the knee surgery. You heard from her knee surgeon as well about the extra opioids he prescribed her at that point. Yes, there was evidence that she was trading pills with other people. She was using medication that she wasn't prescribed. But the medical examiner and toxicologist were clear. The drugs in her system on August 12th did not cause her death and did not meaningfully interact with insulin. They alone would not have been the cause of her death, and they don't interact with insulin. There's also evidence that Casey may have been taking money from her grandparents. Even assuming that occurred, there is no evidence that she had been confronted, investigated, or was facing imminent consequences because of that. Family members testified. Mark said that he certainly would have sought repayment. He would have had a firm conversation with her about it. But he would not, initially at least, want to see criminal punishment unless it was, needed to get that repayment. We heard from her ex-husband, Casey, and he testified he consistently helped her out financially. He bought her cars, he bought her clothes, he paid for the tires on her cars, he paid for insurance. He testified he would have continued to help her out financially. In fact, the evidence shows that Casey was actually quite generous with her money, particularly with the defendant. We heard testimony from both Kylie and the defendant's own mother, Renee, that Casey had paid for, and I believe even her father, Lee, that Casey had paid for a trip to Disneyland for Renee's 60th birthday. And you'll see, and you've seen in the text, that the defendant is giving, that Casey was giving the defendant hundreds of dollars shortly before her death. This is not evidence of someone whose world is collapsing overnight. This was Casey's life as it had been for years. Messy, complicated, imperfect, but certainly stable enough that she continued planning surgeries, planning to escalate up in work, and daily activities. Flaws do not equal suicide. Chaos does not equal an intent to die. And most importantly, vulnerability does not give someone else the right to take control of whether someone lives or dies. Also, Casey was not acting like someone determined to end her life. You heard the testimony just 2 weeks before August 12th, 2 weeks and 6 days. She underwent knee replacement surgery. Dr. West, the surgeon, he testified about performing that surgery and how he evaluates patients before such a complicated and extreme surgery. He evaluated not only her physical condition, and we know that Casey was not lying about this because he testified, no, the x-ray showed that her knees were in severe condition, and one was worse than the other, and that's the first one that he operated on. But he also evaluated her mental readiness for such a surgery, whether she had the motivation to recover, adequate support at home, and the ability to follow through with rehabilitation. She met those criteria, and he testified he would not have operated had she not. The evidence shows that Casey was healing on schedule. She attended her 2-week follow-up appointment about a week before August 12th. She was completing physical therapy. She was on track. And the doctor testified that they were already discussing, although it hadn't been formally planned, he said that at the 6-week follow-up, they were going to talk about doing the second knee, and that was her wish, if the recovery continued as expected, which nothing indicated that it shouldn't. Casey was making plans for her future. Mark testified about how she talked about advancing at work and wanting to get a license associated with that. She talked about getting healthier. Mark testified that she had purchased a treadmill. She was trying to lose weight. And in fact, in the body cam, you'll see it. Mr. Williams even talked about it. There's a treadmill in front of her closet that the officers had to move to get access to that closet. She talked about wanting her own apartment, that she was unhappy living with her grandparents and wanted to get an apartment. You'll see in Exhibit 163 here, she expressed fear of pills being laced with fentanyl because fentanyl can kill a person. About a month before her death, she obtained a new car. We heard from Casey Tanner, her ex-husband, who helped her finance that. I'll ask you to remember, and again, some of these slides, some of these exhibits that have been introduced and that you've seen, I'm going to show you on the PowerPoint. Some I'm just going to refer you to, and you'll have it back to consider in the jury room. But remember Exhibit 17. The day before Casey died, part of the searches that she was looking for, it looks like she's online shopping. She's looking at Lululemon items and lunch pails. In Exhibit 34, we see her shopping list. On August 11th, she went to Smith's. In addition to buying some treats for the defendant the next day that Meggan talked about in her interview with police, she purchased frozen pizzas, dog treats, and a car freshener. These are ordinary, future-oriented purchases, not the actions of someone planning to die within hours. Exhibit 35, there's the receipt for those items. She also had her dog Bella, whom multiple witnesses said that she treated like a child. There is no evidence that she made arrangements for Bella's immediate care after August 12th. Excuse me. You heard that she sometimes portrayed her family as emotionally abusive. And for sure, that we heard that Meggan and Meggan's family, they heard that Casey did not have a good relationship with her family. They would not let her come live with them. They were emotionally abusive. They talked down to her. But the testimony from Kylie and Mark showed something different. Actually, a pretty close family relationship, regular contact, shared events, and continued support. And despite all that speculation, you have heard there's no suicide note, no goodbye messages, no indication from anyone to anyone that she intended to die. If she actually had a good relationship with her family, which testimony supports, despite her telling other people that she didn't, would she leave those things? Her conduct in the days leading up to August 12th shows planning for life, not preparation for death. Instead, what you see is a person who sought attention, particularly from the defendant. Even the defense's own expert, Dr. Hancock, acknowledged that pattern. Casey told dramatic stories. She exaggerated, primarily in medical contexts. Dr. Masteller confirmed that. And over time, those stories, and again, primarily to Meggan, became more extreme, more implausible. And again, Meggan is a trained nurse and would have knowledge. Yes, in the text, which again, you'll have plenty of time to review all of those, you will see, or the ones that were admitted, excuse me, you will see Casey talk about suicide and supposed prior attempts that she made at suicide. But when you look for believable, decisive action by Casey alone, not just dramatic claims about something obviously not true, the kind of action that is actually taken by someone truly determined to die, you will not see it. She had access to insulin. You'll see that in the text. We've heard testimony about it. There were many diabetics in her home. There's different types of insulin. It's not inventoried very well because Mark said he would never throw out, otherwise usable insulin, even if it's expired. She could have killed herself with insulin at any point. The defense made quite a point of demonstrating that she had access to very large quantities of opioids. She could have overdosed on those at any point. And again, she expressed fear, even of pills, even if she's trading pills, and even if she's taking pills that she's not prescribed. She's still afraid that they might contain fentanyl. She could have gotten pills with fentanyl and died much easier that way. And evidence shows that she repeatedly described to Meggan over text how painful and frightening she thought death from insulin would be. Hours of declining consciousness, seizures, organ failure, and particularly what she described to Meggan as her not wanting to die this way, drowning in her own fluids, which is exactly what we hear happened. Instead of real attempts, you see exaggerated claims. For example, in Exhibit 82, she tells Meggan, again a nurse, that she injected 9 full bottles of insulin. This is something that Meggan apparently, quote unquote, believed. You heard testimony that insulin is measured in units and that a single vial contains about 1,000 units. Dr. DeSalvo testified that as little as 38 units could be fatal for someone of Casey's weight. You heard in Exhibit 60, this is a text from Meggan. Meggan herself told Casey way back in 2020 that 100 units would be lethal. 100 units ought to do it. Yet despite these dramatic statements from Casey, which you'll see pretty consistently, what you also see consistently is hesitation, delay, escalating stories without follow-through over years. And all the while, Meggan is supposedly believing them. Again, she's a nurse. Dr. Hancock, the defense's own expert again, agreed that someone with these patterns, he talked about lying, this behavior of splitting, where you're telling something to one person and something to another person and then trying to prevent them from interacting, going to extremes for attention and care. He said, yeah, that person could be very vulnerable. That person can be someone who can be exploited by others. The defendant was a nurse. She understood the vulnerability. She knew the lies. She recognized the control she had over Casey. And yet she didn't treat this as a mental illness. There's no evidence that she pushed for therapy. She did not even confront Casey about what she knew were blatant falsehoods. Think about that. I took 9 vials of insulin. At another time, I took 4 vials of insulin. I've taken all the drugs that I have. I just can't die. My body doesn't accept drugs. Meggan doesn't call her on any of that. She's just accepting what she as a nurse would know is pretty absurd. Instead, Meggan used it. She treated it as an opportunity. What the evidence shows here is a pattern, a long-running game of chicken. Casey escalates the dramatic suicide talk. Meggan pushes the conversation further. More early on in the text, and again, you'll review them, Meggan sometimes does say, Case, this decision has to be yours. I only want to do it if it's your decision. But as time goes on, the text shows that Meggan increasingly encourages insulin use and pushes toward action. And again, the text shows that Casey is deflecting. For years, nothing actually happens. Casey never commits suicide. Casey's never dead. Casey makes extreme, often, like I said, patently unbelievable claims about suicide attempts, but she does not carry one out. The evidence supports that, particularly in the early years, Meggan's goal was to encourage Casey to die on her own. Meggan probably did not want to have to kill Casey. If Casey killed herself, if Meggan could convince Casey to kill herself, that would certainly be easier. It would be cleaner. It would be more convenient. You see that encouragement clearly. Let's look at Exhibit 48. And this is in 2020. Meggan says, there's nothing left for you here. You have to go. You have to let go. It is past time. Remember Exhibit 49. You have so much more on the other side. Exhibit 61. Oh, sorry. Exhibit 48. Yeah, this is what I just referenced. There's nothing left here for you. Everything is ahead of you in the next life. Move forward and stop existing. Exhibit 61. Again in 2020. Are you doing insulin tonight? Meggan asks. Remember Exhibit 60. 100 units is enough, and it's not even detectable in an autopsy. Meggan tells Casey that back in 2020. Meggan even brings insulin home from work back in 2020. Remember and review when you go back to deliberations, Exhibit 62. Meggan says, you didn't use insulin last night. Are you planning on it? Remember Exhibit 63. Are you planning on using the insulin? Exhibit 65. Should I take the insulin back? Because she had drawn it up and put it in the fridge. And remember Kylie's testimony. She remembered seeing it there. This is when Casey was moving out of Meggan's home. and said that she was afraid of Meggan doing something to her. And Kylie said, I saw a vial of insulin in there. That's backed up by the defendant's own statements. Let's look at Exhibit 66. Meggan is saying, there's still shots in the fridge. I drew them up for you and tried to get you to take them. It's on the third text down. Even then, Casey is hesitating, delaying. Remember Exhibit 67. Casey says, I was going to do it last night, but I fell asleep, probably tomorrow. Remember Exhibit 62. Casey explains that she's just not ready. She wanted to talk to Meggan first. She feared missing Meggan. And she said, I just need to do it and get it over with. But I have all these attachment issues. Dr. Hancock testified that people with these patterns, again, are seeking attention, care, and reassurance that their life has value. Yet Meggan does not redirect her toward treatment. Instead, she continues the conversation. Exhibit 51, Meggan asks, what do you have to live for in this life? I truly believe everything for you is ahead of you, not here. I felt that way for a long time, more strongly as time goes on. Over time, it's becoming clearer to Meggan, even despite all this encouragement that Meggan is giving her, Casey is not going to do it. She's not going to do it alone. So Meggan begins offering direct help. Let's get to 2021. Exhibit 52. I will come over and help you do them. I'm happy to come over and help you if you are really ready to be done. Exhibit 53. I don't think you will. And then she says something. She says, something's holding you back. Do some soul searching and figure out what's holding you back. When you are actually ready, you let me know and I'll be there to help you. You won't be able to do it alone. Meggan herself, way back in 2021, knew that Casey was not going to do it alone. Meggan understands the dynamic. Remember Exhibit 70. Meggan suggests drawing up everything you've got and giving it through your port. And then she again asks, do you want me to come over and do it? Still, we see Casey stalling. Remember Exhibit 72. Casey's delaying again. She says, oh, I was going to, my nurse was coming over, then I needed to take Bella out, then I fell asleep. And still we see Meggan pushing harder. Exhibit 133. Honestly, this is Meggan to Casey in 2022. Honestly, I think with the insulin, someone, should probably be me, should stay with you and continue to give you doses so it will actually stay low and you can pass. Ladies and gentlemen, this message marks a turning point. By 2023, the pressure still continues. Remember Exhibit 98. Meggan asks, are you wishing you went through with your plan? Remember 55. I really, really want to be be there with you when you pass. Exhibit 54, Meggan's talking about wanting to be present and she's even coordinating the timing around childcare. Casey again hesitates. At this time, she says, it does not feel right. Go look at Exhibit 54 and see that. Meggan, again, she does say, this is Casey's choice, this is your choice, but again, never therapy, never intervention, never ending the conversation, never calling Casey on what are increasingly dramatic and outlandish lies. By 2024, the dynamic really intensifies. The stories become more bizarre, more absurd. Remember Exhibit 81. Casey, and this is a long exhibit, and I invite you to go through all of it. This is where Casey is inventing this hospice. She's inventing multiple nurses that are coming over and doing different things. And if you'll remember with Dr. Masteller, I took some of these vital signs that these supposed nurses are communicating to Meggan through Casey's own phone during this fake hospice. Dr. Masteller, again and again and again, nope, these vitals are not real. They don't make sense. They're incompatible with life. And every time I asked him, would you expect a nurse to know that? Yes, 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 yes. Even Dr. Hancock, again, the defense's expert, he said he's not a medical doctor, and that's to be fair, but even he said some of these vitals are highly suspect. And yet Meggan continues to play along. She even responds, "It's a total mystery." When she sends her some kind of vital, and pretending to be a nurse, she says, "Hey, have you ever seen vitals this low? Even the doctor's confused." Meggan, it's a total mystery. Instead of challenging the obvious fabrication, she sustains this suicide narrative, and the pressure continues to escalate. Remember Exhibit 58, Meggan tells Casey, "Easter would be a beautiful day to die." Remember 100, Meg says, "It would have been a good day for me to come and help you with the insulin." Remember 57, "Go, Case, don't look back, go." Remember 101, Meggan asks about obtaining insulin and transferring prescriptions because Casey says, "Oh, the pharmacy's out." Again, delaying. "The pharmacy's out, they can't get it." Meggan goes, "Well, see if they can transfer pharmacies." Exhibit 96, Meggan proposes trying insulin the next day. And I'll show you Exhibit 135. And here we're up to June of 2024, just a few months before August 12th. "Case, can you get the insulin? They are keeping you off for 48 hours. Let's try it. I'll come and help you and give it to you regularly and see if it works." Again, that message deserves emphasis. Remember Exhibit 88. Meggan says, "If that doesn't work, I think we should get the insulin. I'll come help you." Exhibit 77, she insists that if they try insulin, she wants to be there to help administer it. Meggan is not letting the topic go. And in fairness, Casey is continuing it going on too, and she's getting more and more dramatic, and she is talking about suicide, but not in a believable way. And what you'll continue to see is delay and putting her off. After Casey's knee replacement, which we know happened July, I believe, 23rd of 2024, Meggan starts trying harder to gain physical access to Casey because at this time, she spent years encouraging Casey to do suicide. Casey's even having pretended to have tried and nothing works. So Meggan starts to think and know, I've got to be there. I've got to be physically present for this to happen. Remember Exhibit 91. Casey, having just had a knee surgery, instead she does lie to Meggan. She says that she shattered her femur. She says that one of her hospice nurses picked her up and dropped her, and this shattered her femur to explain her leg. I think she even sends a picture of it. She's not telling Meggan that she got a knee replacement. Remember Exhibit 92. Meggan, because Casey had been in the hospital with the knee surgery, Meggan offers to come to the hospital and again says, "I'll help you with insulin." Exhibit 99. Here, Meggan is talking to one of these fake hospice nurses or doctors, and she says, "I know she doesn't want anyone seeing her this way, but I feel like I need to come and see her." Again, trying to get physical access. And here again, we see that Casey is delaying and deflecting. "I think I would wait a little while and let her sleep. And then when we do a shift change, we can talk to her and have her get a hold of you and see if that would be okay. Would that be okay with you?" In Exhibit 102, now we're up to July 26th of 2024. Meggan, "Do you want to try the insulin?" Casey, again delaying. "I do, I just don't want to do it until after I talk to Masteller tonight." And again, Masteller is her real primary care physician, but you'll see in Exhibit 81 that Casey is also pretending that Masteller is coordinating this hospice care, that he's the hospice doc. We heard from Dr. Masteller that obviously no such thing actually happened. Still, Exhibit 102, Meggan says, "Do you want me to try and come and help you tomorrow?" Casey, again deflecting, delaying. "I'll let you know after I talk to Masteller tonight." Exhibit 132. Meggan, again, we're end of July 2024. No, you just asked me to help you today, which you've done several times, and I plan on coming to help you and end up waiting all day to hear from you, and you never do. It is just frustrating sometimes. I'm not stressed, but I'm sorry you are. But she sure sounds stressed, frustrated that this is not helping. She keeps waiting for Casey to give her a day. And then she says, and put a star next to this one, ladies and gentlemen, I don't think you want to try to off yourself, and I completely understand. So shortly before, here we are, July 27th, 2024, she's even saying she doesn't think Casey wants to kill herself. I'll show you Exhibit 76. Here we're to August 5th of 2024. Here's where you and I differ the most, I think. And it's the same with Mitch. You two are actually so alike. Your focus is on the now. Like you want relief now. Whereas I was focused on doing the insulin because it's a long-term solution. Not just for the now. You need a permanent solution, Casey girl. Exhibit 94. And again, we're in August of 2024. Meggan, last night you asked me to think about what I thought you should do. Do you remember that? Casey, did you come up with a plan? Amber's here, and you'll see in Exhibit 81 that Amber is one of these fake hospice nurses. And she's just getting stuff set up, but I'm hoping you came up with a plan so you could tell me before I fall asleep. But who knows, I might not fall asleep because yesterday I didn't. Meggan, my thought was give him until Thursday night. And if you still don't have a plan from him, and again, you'll see in Exhibit 81, this is this surgery. This is this fake surgery that Dr. Masteller is supposedly coordinating to fly up to Washington. They're going to do a surgery on Casey that makes her body able to accept medications better so that she can then come back and kill herself. A doctor and a hospice team is supposedly setting this all up for Casey, and Meggan is going along with this. Except she's not really. She said, well, let's give him till Thursday night. And if you still don't have a plan, let's try insulin over the weekend. She's not calling her on how this surgery is absurd, that a hospice and doctors are not going to do that, that surgery is probably not even possible. She just says, okay, yeah, well, let's give it till Thursday and then we'll do insulin. Exhibit 105. Here we're to August 9th, 2024. Meggan pushes again. What do you have to lose by trying insulin? You didn't pay $900 for it, which is a huge blessing. Exhibit 106. Casey gives this very long explanation that I won't read verbatim, but you can review it. Another delay tactic, something about Masteller, and he's gonna try to figure this out, and I'm just trying to figure out what to do. And last we talked, and all the scheduling problems. She's putting it off. She's putting Meggan off. And Meggan again says, I said that we'd give him until Thursday, and if he didn't have a date for surgery scheduled, then we'd try insulin. Again, August 9th, 2024. Meggan is converting talk, drama, lies into action. Remember Exhibit 136, and this is a long one, so I invite you to spend time with it. Casey says she wants to make sure that she gets everything ready. And this is, this is August 10th, 2024, so now we're just 2 days before the event. Meggan responds, hey, I'm not trying to pressure you, I'm just trying to help you think through things, but consider the tone that we're seeing in the messages I've shown you today and in the ones that you'll review back in deliberation. Consider the tone and frequency of these messages from Meggan. Is it true, especially throughout 2024, that Meggan's not trying to pressure her? Casey explains that she does not want to upset Dr. Masteller. Again, that's not real because Dr. Masteller, he's just her primary care doc. He's not scheduling this surgery. She says that she does not want to upset Meggan, which I submit to you is true. She's very concerned about upsetting Meggan. But then, very importantly, she says she will begin drawing up the bottles. At this point, suicide talk has gone on for years without decisive action by Casey. Meggan knows, as we saw in that text, Casey's not going to do it alone. So what does Meggan say? Again, in Exhibit 136 that you'll have to review. I could make it work today, tomorrow, Monday even. You just tell me when. And you don't have to draw it up all yourself. I would come and help you. In Exhibit 136, we finally move to August 11th, the day before the overdose. Casey says in here, second line of the first text, I spent most of the night drawing up the insulin. This detail matters. Even after saying she's prepared the syringes though, she immediately goes back to delaying again. The very next message, my grandpa's in town, my family's coming over, so we could do it either later today. I didn't know we had family coming over. I can't go upstairs and play leg like this. The next message, I'm thinking we need to wait a little bit since my grandpa's brother and family are coming over. I just want to know if you're okay with that. She's putting it off. She's giving reasons why Meggan can't come over. Meggan responds, hey, we can do it later today. Tomorrow would be a bit more challenging just because of the car situation. And again, Casey's trying to put it off. Okay, hopefully they won't stay long. It's Kylie's birthday. We're going to be having dinner, birthday cake and stuff, and they're all here. Hopefully they'll be gone. Do you want me to just keep you updated? And then again, importantly, Casey says, I have everything ready. Now I'm getting irritated because I don't have meds for mass teller, so I feel horrible. I want to do it and pray it works. I just wish Kylie could get off work sooner because the rest of the family are here. They are just visiting while we wait for Kylie's family. Delay, deflection. But saying that, yeah, she spent most of the night drawing up all the vials. She has everything ready. Meggan becomes irritated. That probably won't work. That's lots of relying on other people. I can see if Mitch can work from home and my dad can watch Porter tomorrow. I'll have to see about my dad though. And then at this point, Casey says, if my grandpa doesn't have anything going on, Kylie's not gonna mind giving me a ride to your place. What is Casey doing at this point? She's trying to change locations. Because if she changes locations, if the plan has to occur at Meggan's house, then Casey can deflect a lot easier. Meggan knows that though. Okay, my dad can watch Porter tomorrow morning. So she's coming over at this point. Meggan's coming over the morning of August 12th. At that point, the plan is set. And this is another important one. August 12th, morning of. I'll be there in just a few minutes. Do you want to take some promethazine when I get there so that you are asleep when this is happening? Again, that message warrants emphasis. This is not vague suicide talk anymore. This is preparation for a controlled event, an event that Meggan apparently is expecting Casey to be asleep for. What does that suggest? Is Casey doing it herself? No. So you're asleep while it's happening. And again, this preparation follows Casey's statement that she has already drawn up the syringes. Now let's switch gears. Why would Meggan want Casey dead? Well, we've heard testimony about it. She believed Casey's death would solve her financial crisis. Money explains why Meggan crossed this final line. Starting in 2023, Meggan's texts to Casey show escalating desperation about money. Remember Exhibit 123. This is September of 2023. Meggan says she had to throw out the food from her freezer because it broke and they're going to be eating canned beans. Casey responds that she wishes she had money to give Meggan and feels guilty she has not passed because the life insurance policy would sure make Meggan's life easier. Remember Exhibit 125. This is October of 2023. Meggan texts Casey, Mitch's child support doubled. We get to 2024 and then Meggan's financial pressure is really escalating. Exhibit 126. This is January of 2024. I'm going to lie down and turn my phone off for a while. I am an absolute mess. I lost my job this morning. I'm sick about it. We are going to lose everything, Case. Our house, Mitch's stupid truck, our lives here. I'm feeling so hopeless and so discouraged. What am I going to do? I'm so tired of giving my heart and soul and always being hurt so deeply. I can't keep doing it. What am I going to do? I'm so ashamed. I keep losing jobs and people keep hurting me. There must be something wrong. It goes on. This really, really limits my ability to work and provide for my family. It doesn't even matter what happened. It's done. And I'm going to be the cause of us losing everything. Casey responds, I'm sorry that you've been struggling. How's Mitch doing? Mitch is being sweet and sensitive. But then Meggan says, trade me places. Let me go home and you stay here in this awful place. Remember Exhibit 127. This is February of 2024. She damages her car again. Meggan does. Exhibit 128. If you dying would get me out of this mess and darkness I am in now, I would take it. February of 2024. Remember Exhibit 129. This is, again, February 2024. She says car repairs are going to be $4,000. Remember Exhibit 131. More car. This is July of 2024. There are more car problems. It's overheating. Exhibit 157. July 29th, 2024. Meggan says, I know it sounds so dumb, but I saved up for these pants. I really, really wanted at the buckle, and I'm taking them back now because I can't afford groceries for my family, so it kind of sucks. Casey, I'm so sorry. How much are the pants? Do you have your Venmo card on you? I sent you $320. Might be less because of the card. They sometimes take a fee. Casey, again, Meggan, instead of buying groceries for her family, she's opting to spend over $300 on pants, and Casey Venmos her that money. You heard testimony. Again, we've known that Casey is paid for a Disneyland trip. She's sending that money a few weeks before her death to Meggan. Dr. Hancock explained that in relationships like this, sure, it's someone in Meggan's position in this dynamic could be motivated by the caretaking. That could be one explanation. But he said, when I cross-examined him, that they can also be motivated by things like gifts and money. Evidence shows you that Meggan needed money and she was sick of waiting for it. Frankly, Mr. Williams mentioned this in his opening. He said that Casey was bombarding Meggan with all these texts. And you heard there is a total of 29,000 of them. You don't have all of them. Obviously, that would take weeks for you to go through. But you have a lot, and you'll see that, yeah, Casey was sending a ton of messages, and Meggan was responding a lot. It was probably exhausting, pretending to be Casey's friend and believing all these absurd lies. It probably was exhausting, and she was tired of it. She had been doing this for years. She believed the life insurance, she believed the money, and she had to speed up the process. This was Meggan's investment. She had spent years on this investment, and she expected it to be paid out. Remember Exhibit 156. This is July 30th, 2024, so we're getting pretty close to the August 12th. Meggan says she was $28 short at the grocery checkout, and a nice old lady behind her had to help spot her. This financial pressure matters because alongside that pressure is Meggan's belief that Casey had a life insurance policy with her as the beneficiary. And you may be wondering why, if Meggan is, pretending, or all of these other things that Casey's telling Meggan are so absurd, why would she believe the life insurance policy? Well, go look, because this is the one claim from Casey that Meggan actually investigates. She actually vets it. She actually asks some questions. She does some follow-up work on it. And Casey gives her details that sound pretty credible. Exhibit 30, this is, it looks like legitimate policy stuff at the top. There's a number that is the number that Meggan later gives to John Hancock when she calls after Casey's death. And here we have, handwriting. I believe Kylie testified that this is Casey's. She's signing this over to Meggan way back in, here signed April 28th of 2016. Remember Exhibit 115, this is April of 2020. Casey reminds Meggan that she's going to receive the policy if Casey dies. Meggan asks whether it's going to be enough for cosmetic surgery. She goes, can I get a facelift, tummy tuck, eyelid surgery? Let's look at Exhibit 116. and this is again in 2020, but Meggan is asking follow-up questions. Here's a random question for you. How on earth did you get approved for a life insurance policy with all your health stuff? Casey, I bought it back in 2011. I wasn't as sick back then, but when my dad died, I decided to get one too because my dad always tried to make me get one, so I did. She's giving information that sounds like it could be credible. Oops, sorry. Remember Exhibit 117. This is July of 2020. Meggan presses again. Case, level straight with me, please. Is the policy real? I want to know about this. Casey insists that the policy is real and says that she wanted Meggan to be surprised when an attorney called her if Casey ever died to tell her that she would receive over $1 million. Let's look at Exhibit 119. This is October of 2023. Meggan again seeks confirmation. Can I ask you a question I really shouldn't? Is the money thing for real? I don't think Mitch and I are going to be staying together, and I need to know what I'm looking at as far as being able to take care of Porter by myself and how much I'm going to have to work, whether it be 2 or 3 jobs. I'm so sorry to ask. I really am. I feel really uncomfortable asking, actually. Casey, yes, I promise it's real. I have made sure to keep everything current. I started my policies after my dad died because I knew it would need it with my health problems. I wouldn't lie to you about that. I wanted to surprise you with it. Exhibit 122. I won't go through this whole one. You're free to read it in deliberations, but she's giving legit information or legit sounding information about this policy. She talks about a Mike. Mike's payment he's the one doing the payment, and I got a voicemail, and insurance is so weird to do with it. It's so hard to deal with, but Mike is dealing with this. And let's remember what Meggan does. Not even, I believe, after Casey died, but she's at that point demanding the paperwork from the family, right? She wants the life insurance paperwork. And then in her police interview, the second interview that you'll have to listen to, she tells them, Mike Dolan is who pays it. He's who you should contact. She even says, he's in Casey's phone as my love. He's paid $2,000 premium, talk to Mike, because Meggan believes this policy is real. And she goes further. Remember Exhibit 147. This is the call. This is the call on August 23rd, 8 days after her very best friend in the world, more like her sister, what she says in the call, has died. 2 days after her second interview with the police, where they tell her that Casey having a policy is very unlikely. So she calls. She says, my best friend, more like my sister, has died. The family is not giving me access to the paperwork. She has a policy number, though, and she asks, does that sound like a real policy number? The lady says, yeah, it sounds like one. And then she's told that it's not real. Even her conduct the very day after Casey is rushed to a hospital, unconscious, and we know that at the hospital her blood sugar level is tested and it's at 14. Meggan's behavior reflects expectation of coming into money. You can look at Exhibit 16, and it's on August 13th, the day after the overdose. When Casey is in critical condition at the hospital, you can look through what Meggan is searching on her phone. Some of those searches you'll see include flights, vacations to islands, clothing, and jewelry. Why do that, especially when just weeks earlier, she had to be spotted $28 at the grocery checkout from an old lady behind her? Is this stuff she regularly searches for? Or does she expect to receive a substantial amount of money pretty soon? Despite years of obvious exaggerations and lies from Casey, Meggan maintained this relationship, not because she believed it, everything that Casey was telling her, not because they're actually best friends, but because the evidence shows that the one thing she did believe was the life insurance policy and that Casey's death could bring her more than $1 million. So again, let's turn back to August 12th, the day that set in motion Casey's death that ends up following on August 15th. By this point, Meggan has turned years of talk into action, but she already told Casey back in 2020, 100 units would be fatal. She explained in that same text, insulin overdoses are difficult to detect in an autopsy. And in her own text, she spells out the plan, and you can see it. Remember Exhibit 72, she tells Casey to take extra fast acting. And again, Exhibit 133, which you've seen, but I'm going to emphasize again. Case, honestly, I think with the insulin, someone should probably be me, should stay with you and continue to give you doses so it will actually stay low and you can pass. Exhibit 135. Case, can you get the insulin? They are keeping you off for 48 hours. Let's try it. I'll come and help you and give it to you regularly to see if it works. And finally, again, remember exhibit 137, her last message before arriving, telling Casey to take promethazine so she is asleep while it's happening. This is not compassion. This is planning. This is now execution of the plan. I want to talk about Meggan's control on August 12th. Mark testified that he saw Meggan arrive. He was working from home and he could see from the window that she arrives just before 10 a.m. She stayed until after 9 p.m. that night, just about 11 hours. During that time, I submit to you that evidence supports that Meggan controlled nearly everything. The lights downstairs were dim or off. She later described going over. Renee, her parents, testified that originally Casey said, or Meggan told them, this is just a girls' day. Haven't seen Casey in a while. Gonna go watch some movies. We're just gonna catch up. Mark testified repeatedly that he thought no one was home though. No voices, no TV, no activity. He said he would have gone down to the basement probably a handful of times to get insulin or use the bathroom. And he didn't know anyone was there. He saw Meggan's truck pull up, and to be fair, she did park in front in that circle driveway. But he testified that he assumed that, yeah, one of her friends came over and they must have left in Casey's car from the long driveway that he can't see from his office. He thought that no one was there. Let's look at Exhibit 10, and next to it is Exhibit 176. This is the glucose levels. The first reading is at 9:18 before Meggan arrives. This is Casey. Undoubtedly, this is Casey testing her own blood because Meggan's not there yet. But what Casey's doing is establishing a baseline, and it's within normal levels. It's 87. The defense, I'm guessing, is going to argue and suggested during the trial that she injected insulin before that time, and that there's no way to prove that she didn't do the injection before that time. But the evidence does not support that. Sure, there may be no way for us to absolutely tell whether insulin was injected before 9:18, but Dr. DeSalvo did testify that short-acting insulin has an onset of 15 to 30 minutes. At that early point, the numbers show only a slight downward trend, still within the normal range. More importantly, though, if Casey is doing what Dr. Hancock suggested, maybe one of the patterns, if she's seeking attention, care, but not death, why on earth would she do the one act that is most likely to give her attention and care? Why would she give herself a dose of insulin before Meggan even arrives, knowing that Meggan's coming over? If she's seeking attention and care, does it make sense that she do that before Meggan gets there? For the first few hours, her blood sugars remain normal on the low end, but they're trending downwards. And then that pattern changes sharply. Dr. DeSalvo testified that around 12:30, the data shows a trend consistent with a large dose of short-acting insulin, and it's reflected in the rapid drop from 76 to 43 that you see in there. She explained that the sharp decline is not consistent with long-acting insulin, which would have, a gradual slope, that this is at least, she can't say exactly how many doses have been administered or how much, but she said for sure, what's consistent around 12:30 is a large dose of short acting to see that drop that we're seeing. And again, we know anything over 38 units with Casey's body weight would be fatal, and 100 units would certainly be fatal and would certainly explain why hospital staff was unable to stabilize Casey's blood sugar for days in the hospital, despite continuous dextrose. Dr. DeSalvo testified how insulin works. It sits under your skin and it continues to dissipate in your body. And even with them giving her continuous sugars, they couldn't stabilize her blood sugar over days. Dr. DeSalvo said that would require a huge amount of insulin to be on board. With what we know about the glucose levels, let's look at Exhibit 37. And let's take for argument sake right now that let's say a huge dose was given at 12:30. At 12:47, shortly after that, Meggan texts a number that she identifies as Dr. Masteller, but we know from Detective Farney that this is actually the old number of Casey's grandfather. This is not Masteller's actual number. Hello, Dr. Masteller. This is Meg, Casey's friend. I'm just trying to touch base with you and see where we are at with getting the surgery scheduled. Casey's memory isn't the best, so when I ask her, she isn't always very clear. At the same time, though, Casey's glucose is dropping, and it's starting to drop more dramatically. DeSalvo said that short-acting insulin causes confusion, sweating, weakness, disorientation. Yet Meggan doesn't tell this doctor that she's supposedly texting that she's even with Casey. She doesn't make it clear that, hey, I'm with Casey at the time. She doesn't describe any symptoms. She doesn't ask what to do. She doesn't attempt to verify any DNR that she's supposedly been talked about or told about. She's not seeking medical guidance. She's creating a record, because what did Lee, her dad, testify to when he later showed up? He said, she told me, I've contacted the hospice doc and we're waiting to hear back. She contacted him, all right, but or who she may have thought was him, but obviously it's not his number. But she doesn't give any relevant information about what's happening at the time. Let's talk about the medical emergency. Dr. DeSalvo testified that anything below 50 is hypoglycemia. That's a medical emergency. Before 45, she said it's a critical alert and that every nurse is trained to recognize and know this. The numbers continue. At 12:30, Casey's at a 76, drops to 43 at 1:43, and at 2 p.m., she drops to a 30. At those levels, Dr. DeSalvo said that the symptoms that we're probably seeing are progressing towards seizure and coma. And you know what? We know that happened, because in Exhibit 27, Meggan is texting her own mom at 1:59, and she says, I'm still here with Case. She's not doing too great. I can't even get her to wake up. So we know, at least from this point on, from the defendant's own words, Casey's out of it. And that's exactly what the medical evidence predicts. Yet Meggan doesn't call 911. There's no evidence that she attempted to contact Dr. Masteller again or contact another physician. She continues to control the conduct and information people receive. Dr. DeSalvo testified that by approximately 1:19, so even before we know that Casey's unconscious or can't be woken up, Casey would have been physically unable to test her own blood sugar. And Mark walked you through that process. It's multi-step. It involves, kind of fine motor skills, taking out strips, poking. Dr. DeSalvo said, no, with where Casey was at 1:19, she wouldn't have been able to do that for herself. But the testing continues for hours. Who's doing it? Meggan. She's the one there. Definitively, Meggan is the one after that point. Maybe Casey, we know Casey tested her own at 9:18. Maybe she did a few of the tests earlier when she was physically able to. But at least for 7 hours, Meggan is the one affirmatively doing those tests, just like she said she would. You need somebody to stay with you and keep giving you doses to make sure your sugars stay low. That's exactly what she's doing. And again, no sugar given. House remains quiet, and Meggan is testing to ensure that Casey's condition is worsening. Casey's brain and organs are deprived of the glucose and oxygen they need to survive, and a trained nurse understands that the duration of hypoglycemia matters tremendously. Finally, let's look at Exhibit 16. Meggan is repeatedly Googling, and this, 8/12/2024, 4/23, 4/24. We know from her text to her mom that Casey's been out of it since at least 2. Casey's Googling how low, Freestyle Light, which is the type of glucose monitor, how low can it read? Multiple times. Let's talk about how the defendant affirmatively blocked Casey from receiving medical care for as long as possible, because again, as Dr. DeSalvo testified, the length of time that the brain is deprived of glucose and oxygen makes it more and more irreversible. The evidence shows that Meggan does something even more troubling than simply sitting there while Casey deteriorated. She actively prevented rescue. She invoked a fake DNR, one that, number one, we know never existed. But Dr. DeSalvo explained clearly how DNRs actually work. They don't mean do nothing. They mean no mechanical resuscitation of the heart, no shocking of the heart. She was very clear, patients can still receive oxygen, glucose, antibiotics, comfort care, and emergency treatment. Dr. DeSalvo said that absolutely a trained nurse would know that. And yet the defendant uses this non-existent DNR to affirmatively stop others from helping. Let's talk about when her parents arrive. They arrive around 8:30. Lee testified that he immediately recognizes that Casey's in a medical crisis. He describes a death rattle. He said he's only heard that sound when people are dying. Dr. DeSalvo testified about the death rattle too, and what causes that and how it sounds different than sleep apnea. She said it's a profoundly distressing sound. And yet the defendant told her she has a DNR. Nothing can be done. And that I've already been in contact with the hospice doc. We're waiting to hear back. So Lee's presumption at that time, even though he knows there's a medical crisis, he's not medically trained. Okay, a DNR means I can't do anything. And she's already contacted the doctor. We're just waiting to hear back. But again, we know that Meggan did not give this Dr. Masteller any relevant information that she's waiting to hear back on. She's not contacting again, saying, this is Casey's condition. What do I do? She misrepresented the situation to her own father to actively prevent any intervention. Let's talk about blocking Mark. Around 9 p.m., Mark comes downstairs because Grandpa's been trying to call Casey. She's not answering, so he asks Mark to go down and check on her. And Mark immediately recognizes, just like Lee had, this is a medical emergency. He says, how long has she been like this? And when he mentioned calling 911, he testified that the defendant came apart. Meggan then calls Kylie and again invoked the fake DNR, saying there's a DNR, you can't call 911, trying to get Kylie to stop Mark from calling 911. These are affirmative steps Meggan is taking to prevent 911 from getting involved. Meggan also claims to have held a medical power of attorney, that she is the one that has the responsibility of medical choices over Casey. But we know again that that's fake, that number one, it didn't exist. And again, this is something that either Dr. Masteller or Dr. DeSalvo testified that, no, that's like legal documents. You'd have to go sign paperwork. She would have had to have seen something. It would have to be in front of a lawyer or a notary. Meggan would absolutely know that she did not have medical power of attorney, and yet she's asserting that she has the responsibility over Casey's care. You may wonder why the defendant invited her parents over that evening at all. Let's consider that. The evidence suggests that she probably expected Casey to die much sooner because she originally had dinner plans with them. She called them in, and doing that, she does say around 2, Casey's not doing well, but she's not leaving because again, she needs to make sure that Casey is dead to the best of her ability. And so she calls them in to frame the situation as a spiritual release, consistent with her religious beliefs. She wants Lee to give a blessing of release. Maybe she genuinely believes that will speed up the process. But it also creates plausible deniability because at this point, Casey's been unconscious for hours. If you're murdering somebody, why on earth would you invite your parents over to the scene? It's not something that it sounds very reasonable, right? But Casey's unconscious. Casey can't tell them what's going on. And Meggan already knows that she's going to take steps to try to block any 911 or block any rescue. And Mark didn't know that they were there since, as always, they parked on the street and they entered the house from the back way, the back patio. So no one in the home knew that they were there. And yet the defendant still affirmatively lies to them about what happened. She tells the parents, at some point we're watching movies, we're chit-chatting. Casey went to the bathroom. She was in there forever. I couldn't get her to come out. I banged on the door. I finally got her to come out. She was all loopy. I had to help her to the bed. I have no idea what happened. She must have taken something. She later repeated that same story to the police in one of the interviews. And her account only began to change once she realized investigators had more evidence. Remember Exhibit 22. This is a recorded call where Meggan says, maybe she needs to say that she knew what Casey was doing and didn't help her. This shows, consistent with obstructing justice, which I'll get to in a second, Meggan's story is shifting based on the audience that she's talking to and her perceived evidence, what she knows that the police have against her at that point. And at this time, best case scenario for her, because she knows the police had the texts, she knows some different things. Well, best case is that I knew that Casey was committing suicide and I didn't do anything to help her. But Lee testified that the family did not even learn the full scope of the evidence until shortly before this trial. Lee said that I think up until 2 weeks before this trial, what they believed was still the bathroom story, that Casey must have taken something, Meggan had no idea what, and she just helped her to bed. Let's talk about EMS and how Meggan blocked that. Defendant left the residence before EMS arrived, providing them no information that could have assisted quicker treatment of Casey. And the defense attorney, Mr. Williams, brought this up, that this was because Kylie had just angrily, she used choice words, she swore at her, she said, I'm gonna ruin you, she accused her of murder. And then he introduced this idea of panic, that if you're in a panic, you're not behaving rationally, you're doing things that you normally maybe wouldn't, or that you know that you shouldn't do. But what does she do? Sure, fine, that could explain her leaving the home, but she doesn't leave the scene. Lee and Renee testified that they got in the car, drove a little bit up the street, and watched for about 20 to 30 minutes to see what would happen, because Meggan was so concerned about Casey at that point. If she were truly concerned, she could have approached EMS without anyone in the house, without Kylie, Mark, anyone knowing that she was still there. She could have approached EMS outside and given critical medical information that could have allowed them to treat Casey earlier, to know what was going on with Casey earlier, but she didn't. DeSalvo said that with a blood sugar as low as 14, minutes matter in saving. And yet Meggan affirmatively chose not to give EMS information. I'm going to very briefly address the investigation, because we heard a lot about it in trial, and I'm guessing that Mr. Williams is going to spend some time on it in his closing. Was the investigation perfect here? No. In hindsight, could some things be done differently? Yeah. Is that probably true of every investigation? Yes. Let's remember how this case began. It was dispatched as a medical call. By the time law enforcement understood that they were dealing with either suicide or foul play, the scene had already been disturbed. The patient was still alive, EMS was down there, things were being disturbed, and even the defense's own expert, he seemed to think that's reasonable. Yes, obviously you deal with a patient that's alive before you start preserving the scene. Detective Farney testified that she followed the evidence where it led, and she did collect some critical physical evidence. There was a syringe found on the bedroom floor that, granted, EMS had moved to the side table because it's a syringe and they're, working on Casey. It's a small space. They don't want to step on a syringe, so they did move it. Although it wasn't found until a few days later, there's an insulin vial found in the outside patio trash, wrapped in a rag, and then hidden inside a soda box, missing approximately 100 units. Let's talk about that vial, because it was tested. It was collected and tested, and granted, it wasn't found until a few days later when Mark went to empty the trash, and had he not stepped down on that soda box to compact it, to throw it away, probably never would have been found. But he did find it, and he called Farney, and she told him, take it out, set it up, and whatever you think of whether this was a smart idea, let's think about what we know about that. Mark took out the items, set them up, and it was photographed, and he sent it to Farney. So for sure, we know that vial was handled at least twice, even in the home. We know that someone wrapped it in a towel, put it in the soda box, put it in the outside trash. We know that Mark, a few days later, found it, took it out, set it out for a picture to be taken. And then I think he testified that Farney told him to put it in a bag so she could collect it later. So it's handled by people, it's being moved. And yet testing revealed no detectable prints or DNA on that vial. This matters because it shows something pretty simple. People can handle objects and still leave no forensic trace. There may be many possible reasons for that. Prints may not have been deposited. They may have been wiped away. Or an item may have been handled by someone who might have reason to be wearing gloves. Might that be a nurse? Even if the Fantabox, Mr. Williams made a big deal about this, the Fantabox not collected, it wasn't collected. What could that have told us? Well, let's assume it was. Let's assume that we even find prints on it. It could have contained multiple innocent prints. Casey's, it's her drinks, that's what she drank. Her prints are probably on the box. Mark's may have been there. The Smith's checkout clerk fingerprints may have been there. Perhaps even the defendant from ordinary contact inside the home. Maybe she grabbed a Fanta for Casey and touched the box. Does that tell us, does that answer anything really truly significant about the case? The flaws in this investigation, regardless of what they are, they don't change what we do know. That Casey died from an insulin overdose. Other drugs present in her system would not independently cause her death. We know for sure that the defendant was present for nearly the entire day. And we know from the defendant's own texts that the plan had been building for years. Those messages, ladies and gentlemen, hold more evidentiary value than any fingerprint or lab result. They show intent, they show preparation, they show control. This case is about whether the defendant caused Casey's death. Even if you believe Casey sometimes talked about suicide, the real question is what she actually intended and what the defendant chose to do. Again, this was not compassion, this was escalation, this was a deliberate blocking of rescue. That is homicide. Now let's look at the law. Sorry, I'll try to speed things up. I know you've been going forever. Instruction 32 that the judge gave you, this is count 1, aggravated murder. And these are the elements, and I suggest that you treat them kind of like a checklist. You have to find all of these beyond a reasonable doubt, and I'll talk about that standard in a minute. But basically that means that you have to be firmly convinced of each of these elements before you can find guilt. So treat it like a checklist. The defendant, Meggan Sundwall. We know this is Meggan Sundwall. Multiple people identified her on the stand. We know that the person that we have is the right Meggan Sundwall. This is Meggan Sundwall. And I'll come back to 2 or 3 because that's what this case really comes down to. But under one or more of the following aggravated circumstances, homicide was committed for pecuniary gain. There's no requirement that the money actually had to be real or that it had to be paid out. But the evidence is pretty clear that if Meggan was the cause, that it was for money. You could check that one off. And then also, we know that it was committed by means of administration of a substance in a lethal amount, dosage, or quantity. We know that Casey was given a lethal amount of insulin. So you can check that one off. The law only requires you to be unanimous about at least one of them, but I would argue that the evidence supports you finding both of them. So this comes down, and again, intentionally or knowingly, you have definitions about what those mean. If Meggan is the cause, then yes, they talked about it for years. The intent, their intent, what Meggan knew to be the result of what happened is that Casey is going to be dead. That was the intent. That's the knowledge that Meggan has. So let's talk about causation. That's in instruction 38. It's part of some of these other definitions, but cause the death means the defendant's conduct was a substantial factor in bringing about the death of another, even if it can be shown that some other factor also contributed in a substantial degree to the death, as long as the other factor was foreseeable. The death would not have occurred but for the defendant's conduct, and a reasonable person would have foreseen that defendant's conduct would have resulted in death. The defendant acted, Casey died, the defendant caused that death. You do not have to be unanimous. I want to be clear about this. You only have to be unanimous that Meggan, of course, all of these other elements, but the cause, you only have to be unanimous that she caused. The exact mechanism of how the cause happened, you don't have to be unanimous about. You only have to be unanimous that she caused the death. She could have been a substantial factor if the death is foreseeable. It does not require her to be the sole cause. You do not have to agree on every mechanism of how she caused it. I want to talk about manslaughter, which is the lesser included that is an option for you here, and that's in instruction 33. Sorry, let me get my papers together. And this one here is the aiding suicide. Here, again, you have to be beyond a reasonable doubt firmly convinced of every one of these elements for you to find this. And again, treat it like a checklist if you want. Again, we know Meggan Sundwall. But here, with knowledge that another individual intended to commit suicide or attempt suicide, intentionally aided the individual to commit suicide. I want to hit the aiding really fast. You have that in your definitions. The same, I believe it's 38. Aiding means the act of providing the physical means. Providing there, in turn, you look at providing means to administer, prescribe, distribute, or dispense. I would argue that aiding here, it could mean that she went and grabbed a vial of insulin from the fridge, brought it to Casey. It could mean that she drew up a vial or a syringe herself, handed it to Casey. It could mean that she gave the injection herself. Aiding could mean any of those because she's providing the physical means into Casey's body. But this one, number 2, with knowledge that another individual intended to commit suicide or attempt to commit suicide, I would argue to you that the evidence does not support that. Look over those messages. And certainly I want to be clear. If you find this, if you do believe that Casey was suicidal and that Meggan believed her and that she aided, and you find all of these elements beyond a reasonable doubt, this is the correct verdict. And I want to be very clear, Mr. Williams, the defendant, they have no burden to prove this. So don't expect that anything that they have to say or put up, that it's their burden to prove that this happened. But if you believe all of these elements beyond a reasonable doubt, this is the correct verdict to find. But I submit to you, I argue to you that the evidence does not support this because Meggan did not have knowledge that Casey intended to commit suicide because Casey did not intend suicide. I've already covered that at length. Casey was not suicidal. She may have pretended it. She may have staged it. She may have made it look like it was, but it was dramatic. It was fantastical and it was unbelievable. And this here, right here, requires Meggan to have knowledge that Casey had that intent. When you review all the text messages, I argue to you that there's no way that Casey or that Meggan would have known that Casey actually intended suicide. What this case is, it's different. It's far more serious. Aiding suicide is a different relationship to death than murder. Aiding suicide means that Casey is the principal cause of her death. She's the principal actor, and Meggan merely aided in some way. Murder means that Meggan is the principal cause. So ask yourselves again, who was in control? The evidence does not support that Casey intended suicide or even that the defendant believes she did. The defendant herself texted Casey, again, Exhibit 132, just a few weeks before August 12th. I don't think you want to try and off yourself, and I completely understand that. That's on July 27th of 2024. In her second police interview that you can go back and listen to around the 40-minute mark, she tells police that she didn't believe Casey was really suicidal. She talked about it a lot, but I didn't actually believe she was suicidal. Consider the physical evidence. So a bunch of syringes were found, but I'm going to talk about the 2 primary ones. The one on the floor that EMS moved to the table, and then the one found in the Fanta box days later outside. We heard from FBI scientist Chad Moore. And to be fair, Mr. Williams pressed him on this, and he did say that there are certain things that could degrade insulin or change its properties, its chemical structure. But he testified he saw no protein remnants or degradation products he would expect to see if insulin had ever been in those syringes. Even after cross-examination, he maintained that he would still expect to see some trace. Ladies and gentlemen, the evidence supports a simple conclusion. Those syringes never contained insulin. Even if the other syringes in the house, we know that Mark ended up finding one in the closet after he had to pull up the carpet after the flood. Why would that be there? If Casey is suicidal, or we heard evidence of other syringes found in Kyle's room in a desk, in another room down in the basement. If Casey's suicidal, why would she use her last moments or time of consciousness to go hide the mechanism that she's using to kill herself? Why would she do that? Why would she hide a vial of insulin? Why would she wrap it in a rag, put it in a soda box, put it in the outside patio trash that really only she used, expecting no one else to find it? Why would she do that if she's suicidal? Why would she care? Even if she were trying to maintain the life insurance story, that still makes no sense because guess what? She already told the defendant that the policy covered suicide. Exhibit 153. Back in 2023, Casey says, my life insurance does cover suicide because when I signed up for it, it said I had to go at least 2 years without doing that, but it would be covered after that. So someone controlled that evidence. Someone hid or removed the syringes that were actually used, that actually contained insulin. Someone wrapped that vial, punctured 13 times, suggesting multiple doses given, in a rag and placed it in a box in the outside trash. If Casey intended suicide, again, I maintain there would be no reason to hide the instrument, but someone committing murder would have reason. Casey's stories were fantastical. Her lies were obvious. The defendant, a trained nurse, could see that. Casey was desperate for attention, particularly from the defendant. Casey was seeking reassurance, probably even someone to stop her, to tell her life mattered. Instead, the defendant pushed. Obstructing justice, I'll cover quickly. It's instruction 34. We know that Meggan deleted texts. Agent Sightseer talked about that. They're not, routinely deleted. Her phone's not set to that. They're about insulin. They're about life insurance. They're about suicide. And he said that one of the messages, and you'll see that exhibit, it has a heart being removed off one of the messages, and it tells you the date that happened. It's August 17th, 2024, one day after Meggan's first police interview, when she agreed to provide her phone, but said that she needed to wait a few days to do that. Why? Because she's deleting evidence. Obstruction can also be based on lying to police. And again, we see that, and you'll hear it. She told them originally in her first interview, I have no idea what happened. It's the bathroom story that she told her parents. I have no idea what happened. She went to the bathroom. I have no clue. And then she makes that call. I think I need to say that I knew what Casey was doing and I didn't help her. So obviously she lied to the police. You have to be unanimous. Again, that's one of those ones that you have a special findings form. You have to be unanimous at least to one. You have to agree on at least one, but the evidence supports both. For years, there was dramatic talk, escalating talk, stories that grew more and more extreme, but nothing actually happened. Casey never did anything, nothing irreversible until Meggan stepped in. This wasn't chaos, it was structured, it was directed, it was controlled. This was betrayal of Meggan's specialized knowledge and human trust as a friend. Meggan Sundwall did not just idly watch as Casey declined, she actively controlled whether Casey lived or died. Meggan Sundwall caused the death of Casey Terry with a lethal amount of insulin, and she did it for the money. We ask that you convict of aggravated murder. Thank you.
Can we have a short break while we change?
You can certainly do that.
Thank you very much.
I think that may help the jury too. All right, we're going to take a short break. Ladies and gentlemen of the jury, you were still under the previous admonition that I've given you on a regular basis. You are still not to discuss this case with each other or do any research on your own about the claims or the parties. We're going to take a short break. Let's try 15 minutes. We'll come back and finish up.
All right, Jerry.
Please be seated. Council, let's try quarter after.
Thank you.
Thank you, Judge.
Did he just give them till quarter after 45 minutes? Good Lord. I know what the goal was here is to have jury deliberations completed by tomorrow afternoon. The judge has allotted no more time for this case. And I think that I think that's totally doable. Now, I thought that was way too long. I don't know that she needed to go into all of those text messages, but I do like that, it had a beginning and an ending, and I'm just not buying I'm not buying that this was some kind of intentional murder. I can probably agree with the manslaughter. Yeah. But the jury is like, keep in mind though, they're going to be asked to, to disregard the fact that she was a registered nurse. That does not come in play. They have to figure out, would an ordinary person in those circumstances have done things the same way? Not an ordinary person that's a registered nurse. So because she wasn't being compensated as a nurse, she would, none of that plays into this. So the state wanted to argue that she created the circumstances herself. I don't think she created these circumstances. I think it was totally created by the victim. This is the weirdest case, honestly. This woman, I don't know how she got herself into this mess, but I don't think she's going to get out of this mess without a very short, I think it'll be a short prison term, by the way. I don't know how long she's been in prison. I think she is in custody, but I think it'll be a short prison term. I don't, what are you putting this woman away for life, for aggravated murder? I mean, the woman, she was manipulated by her friend. It was just terrible what she was put through. Anyway, I guess we're going to come back at, it'll be 3:15 here. I guess it's 1:30 there. It's 1:30 there. So maybe we'll get this to the jury by 2:30, 3:00. I don't know. So they'll have a few hours to deliberate. I know he ordered them some lunch. He said he ordered them lunch. I don't know when they're going to, maybe they're eating the lunch now. I don't know. Because they weren't going to take a lunch break. But then the defense asked for a little bit of a break there. Anyway, any questions or comments from the peanut gallery besides me? I mean, I don't know. Do you guys feel the same way? I would be very hard pressed to find that this was, what I think was happening with those text messages is they were so voluminous and so frequent that she just got numb to them after a while. Oh yeah, here she goes again. Oh, she threatened to kill herself. Yeah, how do you want me to help you? She was just kind of, anyway. I think this victim cried wolf one too many times, and this brought her to a swift end. Even her family believed she had cancer and that she was terminal. That's what her family believed. And I think there's more to this story that we don't know. Nothing, the police, it wasn't investigated properly. The police never sealed off or secured the crime scene. And when they did, they just did this one bedroom. They didn't even do the bathroom that's attached to the bedroom. They didn't look at the bathroom to see what was in there. It was a large finished basement. It had a dining area. It had a living area. They didn't look at any of that. They didn't look at any of the rest of the house. So I don't trust the investigation either. They took a bunch of text messages and tried to make a case out of it. I don't know that you can do that in that context. So anyway, all right, we'll come back when they come back.
seated. Go back on the record on case 251-401-132, State of Utah versus Meggan Sundwall. Ladies and gentlemen, jury, thank you for your patience and attention. Mr. Williams.
Thank you, Your Honor. I started this trial talking about principles. The bedrock principles of our country, the bedrock principles of this trial, the bedrock principles of what this trial means versus what one might think, what one might look like, what stringing together cherry-picked text out of tens of thousands could be told in the way of a story by a really skilled lawyer using words. A reality TV show, of course, it's not Nancy Drew. This is, can it be proven here under the rules of this courtroom? And what that means under beyond a reasonable doubt is any real possibility that's in the definition that Meggan Sundwall is not guilty. And it's proof. Our system requires proof, not just a good stringing together of suspicious looking things, suspicious looking words. You heard Detective Farney acknowledge that while we have these jury-picked texts from all these years, this was constant. This was not Meggan pushing buttons. This was quite the contrary. The notion of control is very interesting that Ms. Hunt brought up. I submit to you what you saw and what this dynamic and what you understood from Dr. Hancock is a control stream that goes the other way. The maladaptive behaviors of Casey Terry are quintessentially designed to control the other parties. And we'll get to some of that in a minute. I'm not going to lecture. You took an oath. It is absolutely, I am certain that you held it throughout the trial, that you paid obvious and close attention. You thought critically while this information came to you. I'd rather have a conversation. What I say isn't evidence. The judge has told you that. What Ms. Hunt says isn't evidence in and of itself. Conversation that I would like to have is the principle of proving something, not just showing what it looks like. Meggan certainly made herself look guilty. I said right in opening, you may think she's guilty of a crime, and that means you have to acquit her. In our system, you have to prove it. You have to prove the crime happened. You can't give a long recitation of why it looks like it happened. That's the theme of the case. Keep in mind, these texts, this evidence that the government wants to use as evidence against Meggan are a two-way street. They're both involved in this. They're both texting each other. This isn't one person pressuring her, waiting for years to have the right opportunity to murder her in cold blood for money. That's what these texts prove. And yeah, deletions. Under circumstances where, of the text, of some, under circumstances where even Detective Farney acknowledged it, think and Sight Singer, these are obviously going to be immediately known to be different from Casey's. They have Casey's phone. when Meggan hands her phone over within days, it's obviously going to be known that she tried to delete some texts. And she explained why. That she didn't want to make herself look guilty. She had been accused, and you will determine how significant this was, but I submit that this was not just a calm suggestion that, I'm going to accuse you or you did something wrong. She was screamed out of the house, told her life, her nurse's license, and her life would be ruined because she was a murderer. This reaction, this panic that would be caused, you heard Dr. Hancock talk about it, and that it could be long-term. Is it emotionally driven? It's not passionately driven. When you think that and you hear that as a person, you go into a physiological state of panic. And you think emotionally, oh my gosh, what's it going to look like? What's someone going to think? And you do dumb stuff. It makes you look worse. But it's obviously dumb stuff. You delete some messages and you turn your phone over knowing it's going to be known that you deleted them. And then you're going to hear these interviews. I don't know why the state chose not to play these for you. Maybe it's because they thought it should look worse if you just listen to them all at once. I don't know. You'll have Meggan's full interviews. It's interesting. You'll hear the dynamic of how it goes. You'll hear someone in panic, flailing around, answering the questions, certainly not offering up what we now know happened that night in terms of the glucometer and the suicide pact. She couldn't tell anybody about because that's the nature of the bond that was created by Casey and Meggan, with overtones of religiosity, which preclude either of them. Now, of course, Casey's the only one who's lying in this bond, but either of them were precluded from. It was their own pact. It was their own agreement. The suicide portion had to be secret. It had to be confidential. But I won't dwell on that. You heard from Dr. Hancock, and I suppose it may be true that we could all listen to him all day, and I think our lives would probably go better if we did. But let's focus on the words that matter in the court, the words that matter in the trial. What you will hear there's the first discussion more than an interview. There's Meggan goes to the police station. She's so upset still and believing in this bond and this circumstance that she's upset that she doesn't have what Casey told her she'd get, letters to her, personal items. She's still in the mindset that she is due these things from Casey. She goes to the police station and asks the questions. And she talks about, look, I'm really freaked out about these accusations. The nursing license matters. And what's going on? I'm due some of these things, and they're accusing me and kicking me out of the house. She can't stick around. She's kicked out of the house. You heard about it. I'm going to call the police. You're trespassed. And by the way, they have her number. The police have her number immediately that night. You haven't heard that they bothered to go talk to her. They bothered to just even talk to her for days. But she says, but it didn't help her. I didn't do anything. This trial is entirely about proof that Meggan Sundwall did something. It has to be proven that she did something. And then she spoke in volumes. In our criminal justice system, she told you and everybody, I'm not guilty. And that triggers the process of having to prove not that she looks guilty, not that a really good lawyers with a lot of time can put enough text together to make her look guilty. And the police knew it. 2 weeks from this event, the final interview that you will hear with Meggan Sundwall occurs. Detective Barney and of course Special Agent Hales, who's there for every meaningful part of this case, working for the prosecutor's office. I'm going to go through the statements. This is the final meeting where the police describe what is required in our system. The police tell her, doesn't look good. What does it say? Here's what you'll hear. Hales, we have a suicide or a homicide, one or the other. Here's the deal. There's evidence at the crime lab that we're waiting for processing, and obviously we're waiting for toxicology. I don't know what happened, but I can tell you, Meggan, that from the text messages and deletions of the text messages and the specific way they're deleted, it doesn't look good. The implications of that, and the Detective Barney chimes in, it just doesn't look good. I mean, if you can look at the optics of it, like yourself, take yourself out there and you read the message, Special Agent Hales, perception, that's all it is, perception. You'll hear these words in the interview. And then just getting right to it. Did you inject insulin into the port on August 12th while you were there? Meggan, no, I did not. How more blunt can I be, says Special Agent. Did you inject it into somewhere else, says Barney. Did you give her any insulin? I did not give her any. Did you touch any syringes? Touch DNA. No. Your DNA on anything? I did not touch any insulin. And this is what Special Agent Hales, who works for the Utah County Attorney's Office, said to her. From this point forward, we're going to work strictly off the evidence that we have. When that's going to take some time, we have to wait for toxicology to get there to discuss whether that proves beyond a reasonable doubt that Meggan Sundwall did something in that room. We've got to wait for the crime lab, fingerprints, DNA, right? But there is other things going on, and again, that stuff comes back to you, and it might not. I hope it doesn't. For your sake, I hope it doesn't. The next days are going to be waiting for evidence. They are confronting her about not looking good because of the text, because of the nature of them, because of the words in them, because of the actions of deleting words. The next days are going to be waiting for evidence. And if we can prove through evidence that you did, like DNA, fingerprints, toxicology, we'll see. It's not there, then our charge won't happen. So that goes back to the very blunt question I asked you, and you said no, and that's great. But if there's evidence, again, evidence to prove otherwise, we have a problem, he says. And if there's not, I will ride off into the sunset. There really couldn't be probably a better dissertation than by Special Agent Hales of an acknowledgement of, as bad as it looks, And as much as can be strung together to make you look bad, including your action thing, to go to court, we need evidence and we need proof. And you know where I'm going with that. You saw it in the trial. Frankly, as we're going to turn to a minute, the police and the government ran from the evidence. They ran from the kind of evidence that they need to prove in a court of law that she did it. She did something in the room. You have to understand, of course, this relationship, even to understand the words. The government's case is based on words. A pile of texts. And this notion of control, I submit to you, think about, you saw the trial and you see the evidence. Who's in control? And we'll talk about the 12. The evidence is Casey controlling a relationship, controlling what goes into the conversation, hiding it from others, splitting. You heard about that because, for instance, Meggan has to feel that Casey is miserable, feel that she's dying, just exhaustively get Meggan to feel that. The control is on, according to Dr. Hancock, the control comes from Casey. Is it a relationship between the two? Yeah, there's back and forth, of course. Because as Dr. Hancock described, it works. And people who are like Casey get good at it. This is a psychological truth studied. The information from Dr. Hancock is evidence. It helps us understand what seems counterintuitive. Meggan's role is to agree. Meggan's role is to respond, and I'll be there. I'll help you. I'll be there just to be with you. I'll come over. There's plenty of times you heard about that sometimes Casey's even saying she tried it herself. It didn't work. That's designed to make Meggan come over. It's not in control of Meggan trying to find a time to come to Casey's to cold-bloodedly murder her for money that after a 5+ long years of this. Control, according to Dr. Hancock, is effective. She did a really good job with all of these splittings. She got, according to the psychological literature, pervasive and extensive and long-running control. And then, importantly, Dr. Hancock described how it has to escalate. The control feature for maladaptive behaviors like exhibited by Casey Terry have to keep escalating because you have to keep getting more and different and more intense feedback. It's like a drug. And it's got to be believed. And it's not Meggan's role in this relationship to question, regardless of vitals, regardless of dumb doctor statements, regardless of things that clearly don't seem true. Her bond, her promise under this relationship and role is to unquestioningly respond and stay in it. That is what Dr. Hancock let us know about the direction of control. And the features that are used in this relationship are both ways, right? She gains Meggan as that kind of provider of the need that maladaptive behavior is about. She keeps it private. She maintains it in a way that Meggan shouldn't share any of this. The religiosity component from the very, very start is probably the most important, right? Because what we're doing is wrong. We can't share this. Don't tell anybody. Of course, because if she talked about suicide with any of Megan's other, or Casey's other friends or family, they'd intervene. And it would crush the relationship. That'd be it. She wouldn't have this attachment. It's singular. It's singular. She doesn't do this with other people. This is its own host, its own source of, and let's face it, Dr. Hancock was very honest. There's something deep and painful going on in Casey. This is the behavior, especially at this level, and that's sad. That is sad. It makes it more real, not less real. And it requires her to have more control, not less control. And the role of Meggan is not to question, or that will be broken, that promise, that relationship. And you have to understand I submit. Tell you what election you have to understand. What about the insurance policy discussions and the things you've seen and heard about? That should, I submit, be considered in light of the same thing. It's still part of it. It's all a lie. It's fake. And maybe Meggan would think it's true over all these years, or she doesn't kill her in the cold blood like the state's theory is. And sure would be nice. Remember what Casey tells Meggan about the insurance policy? She keeps wrapping it in, you deserve it. You're all I have. You're the only one who believes me. My family hates me. I don't have this. I don't get this from you. You're the one who says, I'll be with you. I'll be your confederate. I will be with you in your desire to end your life by suicide, even though it's wrong, because you let me know I'm the only one for you. And even the insurance policy is described by Casey in that way. I had a crazy old uncle once, and the crazy old uncle repeatedly said that there was going to be a life insurance policy in it. I'll tell you what I did when he died. I checked. He didn't, by the way. So I went to law school. But let's now talk about this problem that the government and the police run from. This fundamental principle in our courtroom, to your deliberations, they literally run from it or somehow spin it back into a story of words. They don't care about the evidence. This arrest was made before all these things that I just read to you and you're going to hear from Special Agent Hale. All those things I just read to you are said 2 weeks after this event, and they don't, the arrest of Meggan Sundwall 8 months after the events in question. They haven't even gotten all those results back. They don't care. Contemplate a trial in a court of law, not Perry Mason. Contemplate what is being requested of you by the government, by the system, and by the court. A murder where the medical examiner says it's undetermined. They literally have to prove their case around that conclusion. They hold up a pointer. Aha, have you seen all these tests? They know full well if they give him 200 pages of a report that is all about words, he's not going to change his mind. His job is objective. His job is about proof used in a courtroom. He has everything else. He has it as he sits here today. Forget when he issued his report in January of 25. He sent to you from the witness stand, Dr. Murray, the medical examiner, cause manner of death is undetermined. You were to ignore that, I guess, according to the state. The state medical examiner who's seen the proof, the toxicology, he's done the work, he communicated with the police. He looked at the evidence. That's, of course, because he can't find evidence to prove Meggan did something. Because Casey could have done it. So they want you to convict Meggan despite the evidence. The DNA evidence that comes back after she's arrested has Casey's is the only relevant DNA, and it's on the syringe. I'm not sure really maybe what ultimately the government's going to argue to you on this Santa box evidence. But that it's only Casey's. Now you're going to argue, well, since we don't have this evidence, you should go with the flow of the words. That's not the way the system works. That's not the way the principles work. If you don't have DNA after quit, if you do have someone else's, that should be interesting. If you bungle the heck out of the evidence in the investigation, that's not fair. If it leads to not being able to get DNA evidence, fingerprints, same thing. It's not that we're going to prove this to you beyond a reasonable doubt without all the things that Hale said, because we couldn't find them. Because we couldn't find them, reasonable doubt comes from lack of evidence, lack of proof. Toxicology, even though it was bungled, this is truly interesting. We'll get to it in a second. There are syringes all over this room. 3 of them at least are inside the room, or two of them at least are inside the room. There's this one in the phantom box. And ultimately they find a bunch more in Kyle's room, where Casey was known to be with him and to be around him, to be in and out of the room. They're not sent to Chad Moore even for 8 months. And Chad Moore tells you from the witness screen, all I can say is I didn't find any when I tested them. There's a whole bunch of things that can account for that being true and insulin being in the syringes. When you get to what I want to submit has to be disproven as a reasonable likelihood here in this scenario. But she died by insulin, and there's insulin syringes throughout the room. By the way, they didn't even send him the third syringe that was in there. And the medical charts, I want to turn to those in a minute. These medical charts actually tell the story. Linda, the nurse, who handles everything, knows all about patients who have insulin problems, sees them in the ER, everything else, says everything I know about insulin is, I can't tell you when it was introduced. Mass Stellar. I can't tell you when it was introduced. They saw the same chart. And you heard somewhere they found some doctor to say on a witness stand for the first time in her life something about the chart. But she said unequivocally, I can't tell you the insulin got there after Casey Terry was unconscious. It is uncontroverted. What's the problem with the scene? Remember, Meggan goes back, because this box is important. She's been told things. She's been sent a picture of it by Casey. And the difference is on the left is how the box is when Osborne leaves, and in the middle is what they walk into from the body cam of Forney. The room has been tossed. And in the night of, to the right, in Robinson's hand, is an envelope for Meggan. At least it has her name on it, consistent with the text that we know of, that Casey is claiming there's things for Meggan. We know from that interview they had with Mark, Kay, and Kylie, amazingly, when Farney walks out of the room, that they're going through the text saying, oh, Casey's saying, keep some stuff, don't give her this, don't give her that. And Meggan's saying, I've been told that there's important things for me. That illustrates, and then in the interview, you'll hear, in the second interview, Farney says, yeah, we found envelopes, but they were empty. Wonder what happened in between. This illustrates as much as anything the problem with not securing a seat. Farney admitted it is known someone went in and went through that room in between police arriving on the 12th and Farney going on the 14th. Provide reasons to be concerned and provide reasons to doubt. Again, I talked about the syringes, but you think about it. We've got the Fanta box stuff, and it's just not fair. And when I say not fair, I mean not fair to Meggan the accused, but I mean as much not fair to you. It's just not fair to you as a jury for the government to put this decision with these principles in your hand and have the agents of the government just completely bungle the potential that it would exonerate Meggan or not support their theory against Meggan. That's why a good investigation is necessary. It's about fairness. You're going to let the government come in and say, nothing was found, so we win. That's not how it works. It's astonishing. I think it would be astonishing to you. It's just all of us as civilians that you can hear that evidence of a vial, syringe packaging, or vial packaging and everything else is found in a phone call from Mark. You say, toss it in a Ziploc. So photograph it, toss it in a Ziploc bag. You obliterate the value of that. That's a burden of proof problem, and quite interesting, huh? We've got 3 syringes in the end, 1 in a Fanta box with Casey's DNA on it. And then these 4, they're sent a year later, more than a year later, to the lab. The third one that Mark found in the room, after being kicked around, obviously missed by both the first officers and in a hardcore search that Detective Farney says she did, is never processed for any evidence. Never DNA, never fingerprints, never sent for analysis as to insulin. If you don't do these things, it's convenient. That's why we have the burden of proof. Aptitudes, troubleshoot. So lost my Wi-Fi for a second. There you go. Told you and showed you throughout the trial my ability or lack thereof. Can we take it down while
It is.
Okay. The points there are the burden of proof and the nature of our system requires good police work to be fair to the jury when the government asks them to convict on proof, to find things are proven. And that's what I mean by fairness. Fairness to Meggan for sure, but fairness to you, the jurors. Again, the government had made up their mind. The government had a bunch of words. government had a story. Coming from skilled lawyers who've been involved in it from the start. So let's turn to the 12th. Now, with all these kind of chalked up texts and everything, we have an exhibit for you that is just everything. I think it's from the 9th to the 10th. This plan, I call it a script. You can read it for yourself. It sounds like a script. Sure, there's some changing of things. She's certainly not Casey putting off and controlling Meggan. I mean, Meggan's not controlling it. Casey's controlling Meggan. Casey said, let's move it one more day. Let's move it here or there. We know why she needed to move one more day, Thorny said, right? She was doing a drug transaction all of a sudden on the 11th. Christian was coming over. They were doing pill stuff. And we know why she moved it back an hour, right? And we probably do. On the morning, she says, hold on, remember, I want to shower. So I don't, have to die without a shower. And what we know from sightseeing her, who didn't bother to be asked any of this important investigative abilities of phones, is she's moving around. Sure, she's telling Mark, acting happy, acting like everything's fine, so he stays up in his room all day. She's controlling everything. She puts it off an hour. Literally, Meggan, you'll see from the script, Meggan is saying, well, I'll stay at Target then. The night before, Casey went to the store. Casey bought, among other things, carbohydrates and sugar. So let's talk about the 12th in control. While you read that script. First of all, let's put one thing to bed. The DNR is an absolute red herring. It is a nothing. It is a shiny object the prosecutor wants to keep coming back to. The very best example of that is from Dr. Masteller, a powerful point in this trial when asked a doctor if your best friend told you she had a DNR, would you believe her? And he twisted and he struggled and he said, I'd probably believe it. You don't have to have someone who has a DNR to go into this agreement. My best friend and I can have this agreement. It's only illegal if I do something that causes my best friend to die. We know from the history, there's no question that there were probably that Meggan was shown or not shown or told or not told by an astonishingly capable liar about a DNR and references to DNR, that it doesn't matter. She is DNR. In this relationship, the bond and the agreement is not to save, not to interrupt a suicide. It's the word suicide. It's right through the script. Dr. Master, one would believe her. So, I don't know. Suicide? Actual? After years she's been convincing Meggan, but actual in her mind with all this stuff, Casey Terry, she's really good at faking. Is this a real possibility? I want to walk through that night. Is this a real possibility? I submit to you it's probably the most likely, and certainly isn't proven a way whatsoever by anybody else. Cases involved in a quasi-suicide. Those involve people trying to be very, very convincing. We already know that feature of Casey. These are people that have to up the ante. We already know that about Casey. They escalate. They have to be believed. They have to be truthful. They have to be the ones controlling the narrative. Suicide, suicide, don't tell, you're my one and only. You're my only hope to be with. So much so that the other person might even agree, hey, if I needed to, I'd help. They have to prove she had to. They have to prove she did. Who controlled it? This stage is set. It's literally set like a stage. When Meggan gets into the house, Casey has placed the accoutrements of a setting in motion. She's used a glucometer. I don't think anyone thinks that Casey Terry is the one who controlled that narrative, controlled that setting. She has used it. That is telling Meggan, I've done something. That is the inference. Why else are you putting your finger? Already to show, hey, I've used it. Look, I'm going down. I'm decreasing. Why would there be any reason to disbelieve? Why is it not a real possibility at all that she has begun the quasi-suicide? To be convincing, to be very convincing, to make Meggan know she's doing it again. We'll see. The night before, she texts, I'm preloading the syringes. She searches, can I inject insulin? Can I inject saline? Yeah. She's setting up a series of syringes to present as if they're full of insulin, but to be diluted with saline. To try to drive blood sugar levels convincingly, but not all the way. To use a different insulins. She's the one who knows this. Why isn't that not a real possibility? It's what it looks like. Can I inject saline? Insulin is available everywhere. Talks about, you've seen this at the searches. There's syringes in the room. She's not diabetic. There's a syringe in the closet for injecting into the port. We know from the doctors, it probably wasn't used for insulin because of the way it acts. And consistent with this, even Mark understands. She knows that if she wanted to correct because things had gotten out of control, she could drink a Coke. That was rather sobering video. She wanted to change it. She could drink a Coke if she was up to it. And change it has to mean change what she's doing to herself. She's not diabetic, so she normally wouldn't need to change anything. She's bought candy the night before. She's bought crackers, things that she can present as a goodie box to make Meggan feel good, but will also be things she can use to control. But insulin is a tricky thing. It makes long lasting. You use what you thought was a small amount, fast acting on this quasi-suicide. Her doctor, Hancock, even described the circumstance of the patient. And you crash it. Again, by the way, what is some more evidence that syringes would be pre-filled? I'm going to pre-fill them. How do you use saline? And a vial that isn't poked a bunch of times. Poked a bunch of times because you're drawing out little amounts. And your saline, you're preloading your syringes. And your saline, You're making your fakes. A real possibility, that's exactly what it looks like. That talk about words. If we're all into words, let's talk about Casey's words to what she was going to do. And then medical evidence completely supports it. With controls like candy and Coke, and it failed. Now, of course the government's narrative could be true. Of course, it's possible that Meggan helped that failure. Of course it's possible. It's not what's possible, what they can suggest it looks like. You have to acquit if you think it's possible. The real possibility, why isn't it a real possibility? That this is exactly what happened. There's an entire history of quasi-suicide talk. This is the classic example of a quasi-suicide presenter. This is the classic personality trait. This is the classic history. This is the upping the ante. This is the accelerating, et cetera, but it's not a real possibility. And it works. And Meggan learns how it works because she's not waking up. Now, why does the cold-blooded murderer have to go over there and start checking out what glucometer reading means? Meggan's searching up the glucometer. What does the reading mean? How low does it go? That's absolutely somebody who is trying to see if this is a trajectory that will be final. Not because she did it, because it's part of the theater that was set up. It makes complete sense. And eventually says, hey, Mom. The cold-blooded murderer says, hey, Mom, come on over. Hey, Dad, come on over. We have years and years of planning on having you be spiritually involved in this. When they do, and the government somehow is suggesting she uses her parents as tools to prevent assistance. That's horrific. And there's no assistance to be had. Not only did Dr. DeSalvo say that graph is consistent with the last injection of insulin being while Casey Terry was conscious. Dr. DeSalvo and every other doctor acknowledged there is no evidence that anything was injected after Casey Terry was unconscious. So it is unequivocal in this case that Casey Terry could have done anything that was the cause of her death herself. And it has to be proven beyond any reasonable doubt, no real possibility. Meggan, in fact, did something other than be there, that she didn't have to help, that she didn't have to aid. Has to be disproven. A real possibility, for sure, is a quasi-suicide attempt. But at any rate, it's undisputed that anything that caused Casey's death happened when she was conscious and could have done it to herself. And as you heard Dr. DeSalvo say, there was no need or any potential to save Casey Terry early into that flat line. Starting in minutes, certainly going to a couple hours, Dr. DeSalvo said Casey Terry was never going to recover. She wasn't going to recover when Mom got there. She wasn't going to recover after Mark came down. The story was over. The end was something that could not be avoided. That's the evidence. That's what Special Agent Hales promised Meggan would have to be done for her to be in that job. I don't know if that's sound like a lecture, but I promise not to give you a word. But that's conversation that how to think about principles apply. The incredible importance of those principles in the other before, which I fully believe you apply trial. Did not prove that it was not guilty, didn't have a fair shot at full investigation. And minus 3 words of text that make you look at. Unbelievably, to me, I should say, it is a feature of our court system that the prosecutor, these principles are so important and so weighty that the prosecutor gets to go first and last. They get to come up again and talk to you, and I, of course, don't. I get this chance. I'm asking you in fairness, total fairness to your job, to at least think while the prosecutor speaks to you again, and I don't know what she's going to say, what I would say in response. And the principles that we're talking about, including in instructions, this notion of unanimity is tied up extremely tightly to proof and reasonable doubt, because while you're a jury, you are jurors. You are Meggan's peers. This is an experience, and these principles in this trial you apply as peers. You think what you would consider, is this how an investigation ought to lead to a trial for cold-blooded murder, of aggravated murder, the most serious charge in our land? The way you think would be fair for your loved one, your mother or father, your cousin, your peer. And each of you have that experience. Each of you have that ability to consider individually as you discuss within and amongst yourself. Trials are long, it's been long. Sometimes this one, I've had a lot of them, but these can happen that you might not like. I might have done something wrong. I might have done something you didn't like. I might have missed something. If you have any feelings in that regard, I'm asking you to hold me responsible, blame me. This isn't my day. This is my future. This is your peer. This is Meggan Sundwall. This case is not proven. And if it's not proven, you have to obey. Thank you.
I always try to plug that in the wrong way every single time. All right, Mr. Williams just said to you that based on how our system is set up, the principles, the burdens, that I get to come up twice. That's correct, because it is the state's burden. It's the state's burden to prove beyond a reasonable doubt the charges that we have filed against Ms. Sundwall. I and the state embrace that burden. I invite you to test the evidence, review it. That's your job as a jury. That's a burden that we embrace. Let's talk about that burden. Instruction number 24. Beyond a reasonable doubt. The prosecution has the burden of proving the defendant guilty beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there's a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty. That is the burden. That is the state's burden. I embrace it. But let's think about that. Not every possible doubt, not beyond all doubt, not every single doubt has to be covered. You can have things about what happened in that room, in that basement on August 12th that you might have doubts about, but the doubt has to be reasonable. And as long as you are firmly convinced, then your direction is clear. If you are firmly convinced, you convict. Mr. Williams is trying to make this seem that any case, any possible case, to prove it, for you to be firmly convinced, there has to be forensics, there has to be DNA, there has to be all of this scientific stuff. Words are evidence. Those text messages are evidence. Testimony from every single witness is evidence. You do not need forensic evidence to be firmly convinced. Might it be helpful sometimes? Sure. You do not need it. It is not required. I want to turn you to instruction number 22. It talks about direct and circumstantial evidence. I think the example in there is helpful. So direct evidence can prove a fact by itself. I'm going to skip some of this, but you have the direction or instructions so you can read all of it. For example, if a witness testified that he looked outside and saw it was raining, that would be direct evidence it had rained. Circumstantial is indirect evidence. It comes from looking at the related events, putting it together, and concluding that a fact in question had occurred based on what you can tell from the surrounding events. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial that it had rained, evidence that it had rained. Up at the top, facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. And then undoubtedly at the end, before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. Again, to be firmly convinced. And here, I submit to you, the texts are enough. The texts are words from the defendant's own mouth. They're enough. I want to take this raining example that is outlined in instruction 22 a little bit farther. So say that you did not directly see it rain, but you go outside and some of the ground's wet and people are closing their umbrellas. That's a lot to conclude that it had been raining. Let's say you see a dry spot though on the ground. Well, why is there a dry spot? Something's missing. Do you immediately jump to not every inch of the ground is wet, therefore it couldn't have been raining? No. What if the dry spot's in the shape of a car? Do you need a mechanic to come and tell you exactly the make and model of what that car was, or some kind of video to tell you exactly when that car arrived or when it left? No, because that, while it might be helpful, it doesn't change it that you can be firmly convinced that it had rained, because still, with all the surrounding circumstances, you're able to be firmly convinced of that fact. Mr. Williams, I told you this case was about control, and he tried to flip that and say that Casey was the one that's in control here. Casey's controlling this whole dynamic. But let's look at that. Casey did it to people that actually played along. Meggan played along despite all of her medical knowledge, despite every, I mean, I would submit to you that when you go back and you read some of the things, especially in Exhibit 81, they are absurd. You don't even need medical knowledge to know that those things are not true. Does she call her on it? No. This is not Casey controlling the dynamic. Casey, we heard from Casey Tanner, her ex-husband. He pretty early on said, you don't have cancer. She tried to tell him that, and we know that she did lie to her family about that. She never went to the extremes about the details and the absurdities, and the fake vitals, and all that stuff with her family. But Casey Tanner, she tried to tell him, yeah, I have cancer, and he said, no, you don't, you're fine. And then what did he say? She never brought it up again. This is not Casey just having to manipulate every single person. She is doing splitting. She is lying. She is, but she's using where the resources are coming from. And with Meggan plays along this whole time that the resource is not dried up yet. So Casey keeps doing it. And I would argue that some of the text gets so extreme, some of the information gets so absurd that she may have been wanting to be called out. There's even some evidence of that. In Exhibit 81, you'll see she's pretending to be these fake hospice nurses. And she says, maybe I brought this up in my first closing bit, but look at it again, because she does this a couple times. She's pretending to be Kelly or Becky or Lauren or any number of them. He's texting a nurse from the patient's own phone, HIPAA-protected information, all things that Meggan as a nurse would know. Vitals that are absurd, incompatible with life, don't even make sense. And she even says, I've never seen anything so low. The doctor himself is even confused. I'd submit to you that she might be a cry for help even. She's gone so extreme that she's begging Meggan to call her out at this point. Why is Meggan still going along with this? Dr. Hancock himself even talks about cries for help. Sometimes people, he used the example of slitting your wrists. If you do it this way, it's a cry for help. If you do it this way, it's more consistent with you're actually trying to die. You review the text messages. Casey, when things get so absurd that they're patently unbelievable to anybody, not even somebody medically trained, it's a cry for help. And Meggan doesn't give her it. Meggan doesn't call her on it. Meggan continues to play along. She continues to be this source of attention and affection. Mr. Williams wants this case to be, for you to be beyond a reasonable doubt, for you to be firmly convinced, you need all these fingerprints, you need all this DNA. But we know for sure that sometimes that's not available. Like I said with the DNA, with the insulin vial, we know for sure at least 2 different people handled it. And there was no prints, there's no DNA on it. Sometimes the science, for whatever reason, it's not deposited there. Or might it be that a nurse is wearing gloves? I asked Dr. DeSalvo, when you take blood, when you test people's blood, do you wear gloves? Do your nurses wear gloves? She said, yeah, you're dealing with bodily fluids. You're dealing with potential infection. Yes, I would expect nurses to wear gloves. We know definitively that Meggan is the only one in the basement after a certain point had to have been the one testing Casey's sugars past a certain point. Is she wearing gloves? Is the lack of DNA maybe indicative of that? Lack of fingerprints indicative of that? If you need forensics to prove beyond a reasonable doubt, anyone wearing gloves just gets away with it, anything, there's no case? No, because there's also other forms of evidence. And those text messages, I would submit to you, and it will ultimately be your determination. Those are more valuable than anything DNA can tell us in this case. So again, let's step back, let's put the pieces together, and let's look at the picture. Because Mr. Williams actually brought up something that the theory, one of the state's theories seems to align with actually. We heard from Dr. Hancock. So what do we know? Casey died from an exogenous insulin overdose. Mr. Williams said, Meggan didn't do anything. She says, I'm not called, I didn't do anything. And if Meggan didn't do anything, then yes, the answer is acquittal. But if Casey is not suicidal, which you'll find the evidence does not truly support, She's making plans for life. She's buying food. She's doing all of these things. She's getting knee replacement 2 weeks before. She's doing physical therapy. You know, she's trading pills even the night before. Why is she doing that if she's planning on dying the next day? How did that insulin get into her body? The evidence gives you a logical answer, and you do not need to agree. Again, you don't need to be unanimous as a jury on every mechanical step that happened. You only need to be unanimous that the defendant caused the death. And again, I would refer you to that jury instruction on the definition of causation, because that can happen in a number of different ways. But let me give you a theory that I submit to you is consistent with all the evidence. And it's not quasi-suicidal, like Mr. Williams suggested, where people may not intend death, but they're actually using items that could bring them danger. But Dr. Hancock also explained parasuicidal, where they want it to look like it. They want it to look like they're maybe attempting suicide, but they do not intend to die, and they're not going to introduce actually anything dangerous. I submit to you that that's exactly what happened here. Let's look at State's Exhibit 17. So by 4 p.m., you'll see in the text messages between Meggan and Casey that by around 4 on August 11th, it's clear. Casey's tried to evade, Casey's tried to delay. Meggan says, my dad can watch Porter, I can come over tomorrow. So it's clear that to Casey that the defendant's coming over the next morning. And she knows that the defendant's intent, the whole point of the defendant coming over there, is so that Casey can end up dead. So what does Casey do? 9:48 p.m., Exhibit 17, August 11th, Casey searches, is it okay to give yourself a shot with saline solution? If she is planning on dying the next day, why is she Googling if it's safe to give herself saline? Mr. Williams, let's think about that. Someone planning to inject insulin does not search whether it's safe to inject saline. Mr. Williams tried to suggest that, well, maybe she's diluting the insulin with saline. Why? Insulin is a clear liquid. Saline is a clear liquid. And what did we hear from Mark? Casey is familiar with diabetes. Most of the household that she lives in is diabetic. She's been taking care of grandma, who had, I forget exactly the term, but it's diabetes that is so severe that grandma swings back and forth wildly. What did Mark testify? Even 3 units too much could kill grandma. Casey had been taking care of grandma's diabetic needs for years. Casey knows that. You think she's gonna mess around with real insulin if she doesn't mean to die? Absolutely not. That is not reasonable. That is not a reasonable doubt. Instead, right here, Exhibit 17, is it okay to inject with saline? And then, like I pointed out, all of those other texts that you'll find in Exhibit 136, Casey says, I'm getting everything ready. I need to start drawing up the bottles. I spent most of the night drawing up the insulin. Defendant, who is wise to Casey's lies, doesn't let Casey know that. Casey believes, oh, I'm so getting her for some reason. I'm telling her the most insane stuff she's probably ever heard of, and for some reason she's still believing me. The defendant says, you don't have to draw it all up yourself. I would help you. But later Casey says, and again, you'll find this in Exhibit 136, Casey says, I have everything ready. The evidence shows that Casey is still performing, but she's not doing quasi-suicidal. She's not gonna mess around with real insulin. Again, even units too much could kill grandma. Why would she put real insulin in those syringes when she's asking, is it okay to use saline? She fills up those syringes with saline. She's still performing. And even still, she's still delaying. You'll find in the text thread, she's saying, oh, it's Kylie's birthday, there's transportation issues, maybe I should come to your house, my grandpa needs the car, but she's still trying to put this off. If she was truly intending suicide, there's no need to stall. But if she were staging something consistent with parasuicidal behavior, consistent with what we know about Casey, she stages things. She tells her family she has cancer. She does have legitimate kidney issues, so she has medical supplies being delivered to the home. She has saline coming in. She tells them it's chemo. It's only saline. It's for hydration for her kidneys. She does go to the hospital at different times, and yeah, sometimes her family thinks that it's for cancer. And yeah, no, it's not. Obviously, it's bad. It's a bad thing she did to lie to her family about cancer. But she's a mentally ill, vulnerable person. Not mentally ill in the way that she's suicidal. But yeah, she lies to people for attention. And what did Dr. Hancock say? That condition can be exploited. So she gets it all set up. Everything's ready, have it all drawn up. I submit to you, those syringes contain saline. Because what happens? The 2 syringes that are found that are not hidden away after 2 police searches and Mark finds one in the closet after he has to pull up the carpet after a flood. If that's one of the syringes, and Mr. Williams said, oh, well, that state didn't even bother to get that one tested. Okay, if that's the one used, again, it was hidden. If Casey's suicidal, she has no reason to hide it. So who hid it? Had to have been Meggan. The other 2 syringes in play, the one found on the floor of Casey's bedroom that gets moved to the desk by EMS, or the one hidden in the Fanta box. Chad Moore from the FBI, he's a scientist, so yeah, Mr. Williams pressed him on it. Could light have degraded it? Could heat, could time, all of that stuff may have affected it. But he still said, I'm not seeing any of the remnants or any of the changed proteins or any of the chemical structures or anything, even under a microscope. I'm not seeing anything that I would expect to see in those syringes if they actually had insulin. They had saline in them. But yet we know insulin was administered. We know that the vial found in the outside trash had approximately 100 units missing. And again, harken back to 2020, when the defendant herself says 100 units is enough. The defendant, Mr. Williams, it seems to be saying that, Casey's staging this quasi where she's diluting insulin and maybe she gives herself a shot and she's losing functionality. And it has 13 puncture marks because it's so hard for her to puncture it. She's losing the ability. She's losing her fine motor skills. She's fumbling around. You think Meggan, who the whole point is to stay with you and keep injecting you so you stay low, who undeniably is the one to test her sugars for her, a physical act, multiple times after Casey loses consciousness, you think she's just going to sit there quietly doing nothing while Casey's fumbling around trying to drop syringes? No, the whole plan was for Meggan to go over there and help her. But what the evidence suggests is that Meggan swapped the syringes because, like I said, this is a game of chicken and Meggan is smarter than Casey at this point. Casey's been telling her lies for years. Meggan's been pretending to believe them. Meggan knows that Casey stages stuff. Meggan knows that she's saying, 9. And again, this goes right in line with what Casey's patterns. I gave myself 9 vials of insulin and it didn't work. I gave myself 4 vials of insulin. Nothing works. I need to have the surgery because nothing works on me. So why, as Mr. Williams suggested, does she need to demonstrate to the defendant that her sugars are dropping? She could give herself saline and say, see, nothing works. See, nothing works. And this goes right in line with her habit, her history, her parasuicidal behavior. And Meggan knows that. Mr. Williams said that Dr. DeSalvo said I'm going to not quote him directly, but he said something like, after 12:30 or after Casey's unconscious, it's undeniable that no insulin was given at that point. That is not her testimony. She said it is difficult to determine how many administrations were given, how many injections were given. It's difficult to determine at what time they were given. But the one that she said was the one that is most consistent is around 12:30. Something makes sense that at least one, and we know it's a large amount. But she didn't know. She didn't say absolutely nothing after that can scientifically be determined. She said, there's no way to know. But what did Meggan say repeatedly? Someone needs to be with you to keep giving you injections so your sugars stay low. And she's testing her sugars that whole time. And there's 13 puncture marks in that vial. So what the evidence supports. The evidence is consistent with Casey filling those syringes with saline, attempting to stage another crisis, still hoping to delay, still performing, perhaps still hoping that once the defendant actually got there and they're actually at the moment where, hey, I'm gonna inject myself with what you believe is insulin, Meggan, maybe you'll stop me. Maybe Meggan actually cares about me. Maybe that's what's going through Casey's mind at that time. But again, this game of chicken, Meggan's smarter than Casey. So she swapped syringes. Insulin all over the house, syringes all over the house. Casey goes to the bathroom, Casey falls asleep. We know that there's promethazine, oxys, and Xanax in her system in the autopsy. Maybe she takes all of those substances, again, that are not enough to cause her death and would not interact with insulin. But you may be wondering, why would she take substances that have sedative effects if she knows Meggan's point is coming over with the result of her ending up dead? Well, because she thinks she's safe. I have it all drawn up. I have the story planted that nothing works on me. Insulin doesn't work on me. So maybe she fell asleep thinking that she was safe because all that she was going to get injected with is saline. That, again, she checked the night before. Is that okay? Is that safe? So Meggan could have done it while Casey was asleep. Meggan could have, snuck up upon her and gave her a injection. That could have happened. Or she could have drawn up the insulin. Maybe Casey went to the bathroom at some point. Again, Meggan's over there for 11 hours, plenty of time for this to have happened. She could have handed Casey what Casey believed to be a syringe containing saline, that Casey believed to be one of the ones that she drew up herself the night before, still staging the scene, but one with no danger in Casey's mind. She could have handed it to her and had Casey herself inject a syringe that now contained insulin. That's still administration. That's still causation. Look at the causation definition. And again, you don't even have to be unanimous about this theory. You can think any of the other theories that I argued, as long as you are unanimous about that Meggan caused the death. But this theory is consistent with the evidence. And then after insulin was given, it still matters what happened next. The defendant affirmatively monitored Casey's blood sugar for hours after she was unconscious. She watched the numbers fall. She continued even after the monitor read too low. Casey's brain and organs were dying. Mark described her thrashing and gasping by 9 p.m. The defendant saw all of it. And still, she took these affirmative steps to block rescue. She discouraged calling 911, invoked this fake DNR, false claims of medical authority to multiple people. She left before EMS arrived. Again, just to drive down the street because she was so concerned. She needed to see if Casey was taken out. So she watched, but she didn't come up to them outside and say, hey, here's any information that can help you save Casey. Bottom line, Casey here is not on trial. We know she talked about suicide for attention. We know she was flawed. But people who are dramatic, dishonest, or struggling are still protected by the law from being killed. You don't have to have liked Casey. You don't have to have wanted to be her friend. But the law still protects her from being killed. The question is what the defendant did and what the defendant intended. And again, this was not compassion. This was not aiding. A nurse, Meggan, has knowledge and training to understand the risks of death, and the defendant used that knowledge to cause one. This case is about Meggan's control. This case is about Meggan's escalation. This is about Meggan deliberately blocking rescue. And the evidence shows that she killed or caused the death of Casey by an overdose, a lethal amount of insulin, and that she did it because she stood to gain over $1 million. This is aggravated homicide. hold Meggan Sundwall accountable, return a verdict of guilty. Thank you.
Counsel, thank you both. Ladies and gentlemen of the jury, thank you for your patience and attention during this trial. It is now your time to deliberate. But before we do that, we've got to handle a little business about our alternate juror. Trials of this length, we have alternate jurors for a reason. We have one alternate left, and that alternate is going to be excused, but I'm going to give you specific instructions. Our alternate juror is juror number 10, Ms. Moore. You are our alternate. You're going to be excused for the day, but you're not released from your duty as a juror. There have been occasions where alternates have been called back to participate in deliberations. So you are still under oath as a juror. You are still under the same admonishment that you are not to talk about this with anybody until you get word that a verdict has been reached. If we do need you to come back, we will reach out to you. Okay? We appreciate your efforts and your service, but you are alternate. So once call takes y'all back, he'll help you get out. All right? And if we need you, we'll let you know, and we will let you know once a verdict has been reached. Then you're going to be free to discuss this with anybody. I understand the sacrifice. Thank you. All right. Our clerk will now swear in the bailiff. You're then going to be escorted to the jury room where you can begin deliberations.
You do solemnly swear you will take charge of this jury and take them to some private and convenient place where they may deliberate upon the verdict, allowing no one to speak to them, nor do so yourself, unless ordered by the court, and return them to the court when they have reached a verdict, or when so ordered, so help you God.
All rise for the jury.
Please be seated. Counsel, please make sure the clerk has your numbers. It is now 2:42. We're going to let the jury work till around 5 or so. Then they may be excused. They may come back in the morning, depending on where they're at. We'll let you know. Any questions?
I believe so.
There you are.
All right. Thank you. Make sure Brooke has your numbers. Thank you.
All rise.
Well, that was 5 hours of our life we'll never get back. Anyway, yeah, deliberations have started. I think you guys have convinced me. I'm not going with not guilty here, but I think it's going to be a huge discussion. First, they're going to want to look at all those text messages. And I'm hoping, I don't think they did, but I thought that they put the police interview with Meggan Sundwall into evidence. They did not show it to the jury in the interest of time, but I would go back there and I would want to see it. Not just what the police said, she said, but I would like to see what Meggan's demeanor was. You know, was there any contrition on her part? You know, any empathy? You know, I just wanted to see her body language. Yeah, I think they're going to come out of there. It's either going to be aggravated murder or manslaughter. You know, yeah, one or the other. The state was really pushing for that. You know, what was it? I wrote it down. Sorry. I've been sitting here listening, working on images for the story, you guys. Some cool new images coming. Anyway, they wanted the definition. There's different ways you could reach manslaughter. And what they wanted to say was that Meggan created a condition of peril. But the judge says, no, we're not putting that in the instructions, just manslaughter. Yeah, anyway. And, but the judge did read them an instruction that said you cannot consider the fact that she was a nurse and had nursing knowledge. You can only say, what would you have done as an ordinary citizen? Well, first of all, as an ordinary citizen, I find it difficult to sit anywhere for 11 hours straight, especially watching someone deteriorate. But I'm a nurse. I'm a registered nurse. But, I'm not really an ordinary person. I would have known this woman is dying, but by the same token, she's told me she's got a DNR. She's told me she's on hospice. I don't know. This one's just crazy. But if you listen to the expert that explained it, he said that the longer this relationship goes on, and this is a 10-year relationship, over 10 years, this woman is manipulating her friend into believing she's got terminal cancer. She's telling her friend, faking these texts from hospice workers. And what the expert was saying is that over time, you kind of don't even see the things you should see normally that you would say, oh, wait a minute, no, that's not right. Like you just overlook them after a while. Like, oh yeah, you got a pulse of 54. Yeah, whatever, and I don't know. Meggan did she answer? I don't know. I don't think there's enough evidence. The only thing there is evidence to me of is that I don't have the time thing in front of me. Yeah, actually I do. Hold on. I'm going to say from 1:43 p.m. that day, which is now we're going into hour number 5 that she's been sitting there, 5 or 6. From 1:43 in the afternoon until that night, it's very likely, it's highly likely, it's more likely than not, it's beyond a reasonable doubt. There's no way that she wasn't reading her blood sugar. She was checking the little glucometer 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 times. She checked her blood glucose level over the next 5 hours, 5.5 hours. And that's really the only evidence that we have. Oh, Mickey's got to go for dinner. Yep. I am marinating some chicken wings here in this house. And I do have my building live tonight. That's at 7:30. I'm going to be working on my little house thing. The little coffee shop house that looks like a coffee maker that's teeny tiny. Yeah. So I'll be working on step 2 of that tonight. So I hope to see some of you there for that. If not, enjoy your evening. Do I think they'll come back with a verdict tonight? No. Like I said, if I get back there, I want to see those interviews. There were 3 interviews. I want to see at least that first one that was an hour. And then I want to look at those text messages. Let me see the text messages. I want to see them for myself. Anyway, because I don't know what context they were being read in, what was coming between, because they only picked and chose out of those. What they did was a word search. They put all those, they dumped 28,000, they had 28,000 text messages, and they had some program that you could search everything that says insulin. So they pull up all the messages that say insulin. I want to see what was going on between these relevant text messages. And am I going to take my time? Yeah, I'm probably going to take my time. I'm that juror. Yeah, that's me. I'm the one. Yeah. Okay. I'll see you guys in the next video. Hopefully, it's probably going to be tomorrow. I would think the verdict. It's 3:20 there. They're going to elect the 4-person. I don't know what their eating situation was. If they got a quick lunch or if they're having lunch now, a late lunch. I don't know what they're doing. If they're going to get them dinner, we'll see. But you're having pulled pork and egg noodles again. Yum! Love leftovers. Yeah. Not here tonight. Well, I have some macaroni and cheese left over, but I don't want it. Or maybe I'll eat it with the wings. Who knows? All right. I'll see you guys later. Take care, everybody. Bye.